I changed the lock because him, my sister, and my aunt tried to come over and put me out, and they tried to remove everything out of the house so we can have to sit on the floor.
I don't need to put any.
How are you removing the furniture, John, when me and my kids are sitting on it? How are you removing everything out the house and taking it to Pam's house when me and my kids are there using it? I would never do that to you. Shut up. What things? You don't have no thing.
Court does call the case of Fixing Housing, 401k, Florida, I think, versus Erica Ward and Aaron Ward.
Good morning, Your Honor. Zach Revolt on behalf of the plaintiff.
Okay. And are the wards here? They are. Okay, good morning. All right, what is plaintiff's claim in this case?
Yeah, Your Honor. So plaintiff is seeking a possession judgment against the defendants related to breaches of a commercial lease between the parties. Ultimately, plaintiffs are just seeking a trial date to get a possession judgment that can be executed as soon as possible.
All right. I don't know, counsel, if you received a number of different documents filed by, I think you folks are represented by Donna Tobe.
Yes, Erica and Aaron
Okay.
Ward, the tenants.
So, counsel, did you receive those?
We did, Your Honor, but we did not receive them actually until like Wednesday evening around 5 p.m. So very late.
Yes. And so, I mean, there have been some answers, but I'm not sure why she filed an ex parte motion to adjourn. I think they would be entitled to an adjournment for a week in any event. So what I'm going to do is I'm going to put this out 1 week, not granting her motion because I don't think it was proper to be filed as an ex parte motion. But there is an answer to the complaint, which it seems to me in reviewing it has potential counterclaims and a request to suspend the plaintiff's eviction action. So we need to deal with all of that, but I guess we'll have to wait till next week to do so. So what I will do is I'll adjourn these proceedings, folks, to November 7th, 2025. That's at 1 p.m. Folks, that is a in-person proceeding, so everybody will need to be at the courthouse.
And
Okay.
Your Honor, if I may, would you like my client representative in person as well?
Given, normally I would say that counsel can, for the plaintiff can represent it, but it would likely be fruitful if there was a representative, given what I see in the documents file.
Understood. Thank you.
All right. Thank you, folks.
Thank you, Your Honor.
Thanks, Your Honor.
Court does call the case of Maple Heights Apartments versus Jeffrey, is it Payette?
Yes, sir, it's Payette.
I'm sorry, say that again, sir. You muffled there.
I said, yes, it's Payette.
Okay, got you. You're still muffled, but I got you. All right.
And good morning,
Maple
Your Honor.
Heights.
Yeah, good morning, Your Honor. Sean Mock for the plaintiff.
All right. And what is plaintiff's claim in this case?
Yeah, this is an action for non-payment of rent seeking possession only. The rent to retain through the month of October is $1,650. Court cost of $170.05. So the total amount my client's seeking right now through October is $1,820.05. Payment last made on this file, $500 payment made September 30th, 2025.
All right. Sir,
Yes,
how are you intending on getting this paid?
I could pay it all off that payment that they talked about this month and next month's rent, November's rent, all in November. I just need the payment plan. That's all. I could, but
I'm
my
okay,
job-
hold on, you're muffled again. I don't know what's wrong with your mic. I can kind of make out kind of what you're saying. You said you can have it all, including next month.
Yep.
when do you think you can have that?
Before November ends, I have all of that before the month of November ends. What to have me in December, what I would be on track then.
Gotcha. Okay, so here's what I'm gonna do. You're entitled to an adjournment, so I'm gonna adjourn this matter out to November 7th, 2025. What at 1 p.m. That's an in-person proceeding, so everybody would need to be at the courthouse. But what I'm gonna suggest you do, sir, is contact the plaintiff's counsel and see what you can work out in terms of a payment. Sounds to me like you've got a plan in place. See if that'll work for them.
Okay, thank you.
Thank you, Your
All
Honor.
right. Thank you. All right. What are we doing on this case?
Hi, good morning, Your Honor. This is a case for a termination of tenancy stemming from multiple breaches of a lease, a residential lease agreement. We're seeking, basically going to be asking the court for a trial date for us to seek a judgment of possession. I will note, Judge, that I did receive, it looks like, an answer in affirmative defenses from defendants, as well as a demand for a jury, as well as a motion for summary disposition. And so I think just looking for a scheduling order, Your Honor, to address all those issues.
Well, that's not entirely how we would do it. I guess the summary, since this is a summary proceeding, there's a question of whether or not rental payments were accepted.
Yes, Your Honor, that is correct. We did move for summary disposition in this case on the basis of what we believe are multiple park forest violations. Attached to our motion are exhibits, the first of which being bank statements showing about 3 months worth of rent acceptance after the August 22nd move-out date specified on the notice to quit. The second exhibit we have is a signed HUD recertification signed by Mr. Fan and the building manager, Mr. Christopher Writings, if I'm pronouncing that correctly. That's from September 30th. And lastly, we have a notice of processing of that HUD recertification and a subsequent rent increase that was sent to Mr. Fan. That rent increase was actually set to take place tomorrow. All of which occurred, several months after the expiration of the notice to quit, and aligned pretty neatly with the dictates of Park Forest there. And I will note, just briefly for the court, that Mr. Fan is with us here on Zoom. However, he has recently suffered a stroke, as a result of which his blood pressure consistently sort of reaches dangerous highs in stressful situations. So I just wanted to flag that for the court in case he does become unavailable momentarily. But in any event, for the sake of his health and on the basis of those pretty straightforward notice violations, yes, we are asking that you grant our motion to dismiss today.
Your Honor, if
Yes, go ahead.
if I may address that, the Park Forest case doesn't apply here. This is not a non-payment of rent termination of tenancy. This is a termination of tenancy as it relates to multiple violations of, unauthorized destruction of process or unauthorized modifications of premises, destruction of property, aggressive behavior, all other types of.
Yeah, but that's fine, except that the basic premise behind Park Forest isn't necessarily that it's a non-payment of rent case. The basic premise is that the landlord has done things that have led the tenant to believe that the tenancy continues, despite what their complaints may be, whether it be non-payment or whether it be termination.
Understood, Your Honor. Understood, Your Honor.
So,
if I may, Judge.
Yeah, go ahead.
We have been engaged with Mr. Fan's prior counsel in negotiations of a settlement with respect to this issue. They have been on notice that we have been postponing filing the lawsuit as we engaged in those discussions. It wasn't a situation in the Park Forest where the tenant was led to believe that the notice to quit was waived. Here, at all times, prior counsel and Mr. Fan was aware that we were continuing to enforce the notice to quit, and we were engaged in settlement discussions as a result, as it relates to that. as late as recent as end of September, Mr. Fan's prior counsel did identify that they could not reach an amicable resolution and suggested that we go ahead and file the complaint at that time. So this isn't a situation where Mr. Fan was led to believe that acceptance of rent or other actions waive that termination of tenancy notice. In fact, at all
Well, I
times.
think that's going to be a factual determination. I don't know that one that I can make just on the thing. I understand what you may be saying, but, and I'm not sure. Well, I won't go into that. All right. So first thing is I'll need an answer to the motion for summary disposition. How much time do you need to do that, counsel?
Let me look. Sorry, Judge, just looking at my schedule. I'm out of town next week. Is it possible?
Then we'll do it then. No, go ahead.
Yeah, no, is it possible to, do you need an answer date or a hearing date?
Yeah, well, I just need, how much time are you gonna need to file an answer, and then I can give you a hearing date?
If I could file an answer by the 14th, that would be sufficient time for me, Your Honor.
All right. So I'll indicate answer to motion by November 14th. I'm not gonna need much time to necessarily look at that and grasp the issues. So when's my next Tuesday? 3? No.
Oh, Tuesday, sorry. December 2nd, after that.
That's my next day.
I'm sorry, November 18th.
November 18th. I can, if that gets in by Friday, then I can look at it and be able to deal with it over the weekend. All right. So what I will do is to move this along, I'll need the answer to the motion by the 14th, and then I will set it for a hearing on the motion and a pretrial for November 18th. That's an in-person hearing. That's a Tuesday, and that will be at 9 a.m. And then I'll hear argument on it and make it, and then we'll see whether we go forward.
Thank you,
All
Your
right.
Honor.
All
Judge,
right.
Judge, I'm sorry, Your Honor.
Yeah.
One housekeeping matter. I will note that Mr. Fan filed a complaint against Mr. Ridings in a separate matter. Is that it's case number 254C1603. It looks like it was a pro se filing. Is the court going to address that in due course, or is that something that we would consolidate?
My short answer would be no, but give me, you have it?
I do. That was filed as a general civil matter.
So it's before Judge Barr.
Correct.
Okay. When was that? When was it filed?
It was filed on September 29th, and I'm not seeing any activity past that.
So nothing has
There's
gone
no
forward on it. All right. What I will do, I don't know that I can give you a straightforward answer. It's likely that what we'll do is we'll contact Judge Barr and probably bring it over, because it doesn't make sense to, I don't know what the issues are in that filing, but it would seem to me that if they relate to the tenancy, it would be best that it be handled in one place. So
And it looks like
I will talk to Judge Barr about that, and then we'll deal with it on the 18th.
Thank you, Your Honor. I appreciate it.
All right. Okay. Thank you, folks.
Thank you so much.
Thank you, Your Honor.
Take care. Seattle, have a good weekend.
We'll try. Thank you, Your Honor.
Yeah, all right. Take care, guys. Nicholas Schultz, Lake Rental 2 versus Ken Olson II and Courtney Olson.
Good morning, Your Honor. For the record, Salem Saman appearing on behalf of the plaintiff.
Okay, I see Ken Olson.
Yes, Your Honor.
All right. Is Courtney here or no?
No, she's at the kids' Halloween party at school. I do apologize. I'm handling it for her.
She's at the kids' Halloween party?
Yeah, at school, our 8-year-old daughter.
That's an acceptable excuse? No, I'm kidding. No, I'm not.
I hope so.
I'm not going there. It absolutely is. I still don't understand this Halloween thing, but whatever. All right. What is plaintiff's claim in this case?
Basically, it's a non-payment of rent matter, Your Honor. My understanding is that the defendants in this case have represented to my client that they hope to be able to pay everything within a week. So if we can schedule this out 2 weeks and give them a chance to do that, maybe they'll resolve the issue.
Okay, would that be inclusive of November?
Actually, everything should be paid. It's about 15,600 includes
They did make a
November.
partial payment.
Oh, they did make a partial payment of 2,500, but again, they said that they will catch it up.
Okay, let me stop you, counsel. How much is currently owing?
15,600, that includes November.
That is,
Minus 2,500, right, Ken?
yeah, I paid 2,500 yesterday. I paid 2,500 last week. So that's 5,000 there. So I owe $5,400 to make rent current as of right now. November will be additional 5,200. But that's not due till tomorrow. So as we're talking, as of current right now, I owe $5,400.
That's
Is everybody in agreement on that?
Yes.
Okay.
Big
So
difference.
5,400 plus cost, right?
That is correct, Judge.
Okay, so Mr. Olson, you've indicated, or it was indicated, that you can get that paid plus your November by what are you, well, why don't you tell me what you are intending on doing?
Well, I tried to make another payment this morning, but I sent Linda a screenshot of my bank. The web banking is down. So I was like, this perfect day for that to happen. So she's seen it and said, okay, I'm going to have the $5,400 paid. I'm going to pay $2,500 today, or figure out how I can do it with the bank. Because we do it by Zelle. And then you can only do $2,500 per day. I'm going to send another $2,500 tomorrow. And then I'll send another $400 the following day. That'll get this paid up to now. And then November rent will be paid within the week. I'm finished up a job now. I'm on now, and I'll be paying November rent within a week.
Okay, do I have the 14th? All right, so let me ask it this way. If I adjourn this out 2 weeks, as counsel suggested, to the 14th, you could have everything paid and then this matter can be dismissed. And while you're wonderful people, you don't have to come back and see me.
That would be great.
Which
you're
part?
funny and all, but
Not coming back and seeing me?
I mean, you're pretty funny.
You know,
I like that.
I am so sensitive, and I'm hurt. Okay, so
well, you gave the guy a
here's
hard
what
time
we'll
about
do.
his college. That was pretty funny.
All right, folks. Here's what we'll do, and I think it may be a fair solution to work everything out. I'll adjourn this to November 14th, 2025 at 2 p.m. And that is an in-person proceeding, but if everything's paid, then it's certainly a dismissal can be filed and you folks don't need to appear. But if it's not paid, I'll need to have everybody here.
Okay.
Okay?
Yes, Your Honor.
And a Halloween party will not work as an excuse. No. All right. All right, guys. Take care. Thank you very much.
Your Honor, God bless.
All right, thank you.
Yeah.
Right.
Covington Apartments versus Alicia Sharp.
Good morning, Carolyn Cohen, P49391, appearing on behalf of the plaintiff.
Alicia Sharp. She is not present. Would you paid for the second service? Would you like to take a default?
Yes, I would like to take a default judgment, Your Honor.
If you raise your right hand to be sworn. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
I do.
Go ahead.
Your Honor, this is a health hazard based upon a roach infestation, which has caused problems in the premises, and there's been opportunities to try to remedy the problem, and the defendant has failed to appear, and I am requesting a default judgment today with a 10-day writ period.
And she's failed to correct or cooperate in the abatement of the health hazard. Is that correct, counsel?
That's correct, Your Honor.
Okay, I thought that's what you meant to tell me. Judgment to the plaintiff, that is by default for possession There is no redemption amount with the writ to issue in 10 days.
Thank you so much. Have a wonderful day and happy Halloween.
Lakestone versus Christine Fairley.
May it please the Honorable Court, Steve Gann, P 78219 for the plaintiff. I believe I saw her on the screen.
Yes,
Oh, there
I'm
she is.
here.
Okay, I need a camera, ma'am, if we could. What is plaintiff's claim?
Current balance due owing is 7,300, 7,372, 7,372.97. Court fees of 252 for a total of 7,624.97.
All right. Ms. Fairley, how are you intending on getting this paid?
I have already sought help from DHS, and I'm
I'm
working
sorry?
on that. I've sought help from DHS. I think I put a filing there.
So you submitted an SCR?
Yes, I submitted an SCR, and I'm working on paying that down this month. I submitted a check payment that they'll receive in 5 days from my bank, and also I think I submitted a money order about a week ago for $1,400.
Okay, so that was a lot there. You did an SCR.
Yes.
You sent in, I'm gonna take it in a different order. As you said, you sent in 1,400 a few days ago, or
Yes, I believe I think Monday, I think.
you sent it to
My
them on
days are
Monday?
jumbled up. I'm sorry. Yes, I
No,
sent
it's
in,
okay.
I sent in 1,400, and I applied for an SCR, and then I submitted $1,000 from my bank account.
Got it.
Which
Okay,
they'll
that's
receive
that's the one thing I was missing. So you think $1,000 will get to them, you think in 5 days?
Yeah,
Or
it'll for sure
thereabout.
get to them in 5 days. It's from my Huntington bank account. They can
Got it.
cut checks straight from my bank account.
Okay, so that'd be about 2,400.
Yes.
You're gonna have November rent click in. You've done the
Right.
SCR. How many people are in your household?
It's just me, Your Honor.
Okay, so just so you know, with the SCR, the maximum amount that they would give if they approve it is only about $410.
So there's other options that I could seek out, also other charity donations and stuff
Yes,
like that,
and I
which
mean, you can call Housing Access for Washtenaw County, Hawk, and that number was on the, should be in your packet that you received, as well as the presentation that was done at the beginning of the court session.
Yes, I'll
Okay.
reach out to those numbers also.
Okay, so I'll give you an opportunity to do that. With the SCR, you need to file also in your packet, the rental assistance form. You need to file that with the court, and actually you already have. Never mind. You're ahead of me. All right, so we already have the rental assistance form. So you're gonna be entitled to at least one adjournment and maybe another one, okay?
Okay.
So right now, we'll just adjourn it out a week, see where we are at that point, okay?
Okay.
So I'll adjourn it to November 7th, 2025 at 1 p.m. Ma'am, that is an in-person hearing, so I'll need you down at the courthouse, okay?
All right.
All right. Thank you.
Thank you.
Thank you,
All
Your
right.
Honor.
Thank you, Mr. Gann.
Please call the court. You have a great day.
You do the same. Sile Farms versus Taylor Smith.
Casey Matson on behalf of plaintiff.
And I think Miss Smith is here. Yes, there
Hi.
she is. Hello.
Hello.
All right. What is plaintiff's claim in this case?
Your Honor, we have rent to retain of $5,320.83, costs of $190 for a total of $5,510.83.
And Miss Smith, how are you intending on getting this paid?
Hi, so I filled out the SCR and then I can make this month's payment next week, but I was seeing if I could have to like before the end of November to pay off the rest.
Okay, let's back that up a little bit, okay, so that we understand what's going on. You've done the SCR.
Yes.
So with the SCR, there's a form that came in your packet called a rental assistance form.
Yeah.
You'll need to fill that out with the tracking number.
Okay.
Okay. And that it needs to be filed with the court by Wednesday.
Okay.
Okay?
Oh.
Now, the next thing is that you said that you could make a payment. So what kind of payment, how much of a payment can you make, I guess is what I'm gonna say.
1,500 by next Wednesday. Is that okay?
Well, if I said no, what would you do? No, never mind. You could no, don't answer that. I just thought I'd throw that out there. But you can pay 1,500 by the 5th, you think?
Yes.
Okay. All right. And then how are you intending on getting the rest of this paid, or what's your plan?
So I got let go from my last job and I just started working at this job last week. I had my at my new job last week. I had my employer write a letter for me.
Okay,
And
so
yeah.
basically, let me shortcut it a little bit. Basically, you're looking to get some type of plan in place, and you hope that you can work out something to get yourself clear by the end of November.
Yes.
That's what you're looking at. Okay. So here's what I'm going to do. I'm going to indicate you're to pay the landlord the 1,500 by the 5th.
Okay.
I'm going to adjourn this hearing out to November 7th, 2025 at 2 p.m. That's an in-person hearing, so you'll need to come down to the courthouse.
Okay.
Okay. What I'm going to suggest is that you contact either the office, your landlord office, or the attorney's office, and see if you can work out some type of payment plan to get yourself all caught up.
Okay, perfect.
Okay.
Okay.
So we'll leave it that way. And just so you know, how many people are in your unit?
2. Just me and my daughter.
Okay. So just so you know that, so you're not relying upon it that to a great extent, even if you were approved for an SCR, that's only about $520.
Okay.
Okay. Of that amount. Okay.
Okay. Thank you.
All right. Thank you. Have a great weekend.
You too.
Your Honor.
Sile Farms versus Marcel Doss Jr.
Casey Matson on behalf of,
Go ahead.
Casey Matson on behalf of plaintiff.
And also Justice Richter.
Hi,
Hello, what's your name?
Justice Richter.
All right. All right. What is the claim?
Your Honor, we have rent to retain of $1,498.09. Court costs of $230 for a total of $1,728.09.
All right. Ms. Richter, how are you intend on getting that paid?
So I do plan on having it all paid up by Monday, as well as November's rent.
Okay.
The reasoning for me not having it paid was my brother, I'm his sole caretaker, and we just found out he has to have another open heart surgery. So I honestly forgot about rent. And then I'm like, oh my goodness, I gotta pay rent. So it was kind of just like life. So I plan on having that all paid.
So your brother was having surgery and you forgot about rent?
Well, I've been going to his doctor's appointments. We're scheduling his open heart surgery.
Got it.
Yeah, and this is our
No,
first
you know what,
since my
Ms.
mom
Richter, I kind of said that facetiously. I get it. All right. Okay, I understand that. So you think you can get this all paid by Monday, including November?
100%.
All right, so here's what I'll do. I'll adjourn this to November 7th, 2025 at 2 p.m. Now that's an in-person hearing, but if you have everything paid, just double check and make sure you got everything paid. They're going to dismiss this case.
Okay.
Okay.
Thank you.
You are so welcome, and good luck to you, and best wishes for your brother.
Thank you.
Thank you.
Arbor Meadows versus Rachel Cox.
Good morning, Your Honor. For the record, Daniel Landman, P35797, appearing on behalf of Arbor Meadows.
Good morning, sir. And Ms. Cox?
I'm here, Your Honor.
All right. This is a termination of tenancy action. Plaintiff's claim in the case.
Plaintiff's claim, Your Honor, is that Ms. Cox's dog bit a guest of another resident. Pretty severe bite to the right hand. Police
Yes.
were involved. The dog ran loose.
All right. Ms. Cox, what's your position on this?
I have several actually. My dog is not aggressive whatsoever to kids, humans, it doesn't matter. She is very friendly. The only reason why she bit was because he tried to restrain her and grab her collar, and she was scared.
Was, well, where did I don't think there's a dispute that the bite happened. Where did it take place?
It happened in our neighborhood, in Arbor Meadows.
Okay, so it was in the neighborhood?
Yes.
Okay. Who was the dog leashed or?
She was outside, and a neighborhood kid has been letting her off, and she got loose because someone let her off.
Okay. All right.
Your Honor,
So,
the
ma'am,
dog,
are you?
the
Go
dog
ahead.
was loose. It went after another dog. The victim tried to separate the two dogs and was bit.
Okay, that's it. Okay, I got you. Okay. What, ma'am, are you gonna have an attorney in this matter? How are you intending on proceeding in this case?
I don't have an attorney, no.
All right. So here's what I'll do is I'll adjourn it out for you to try to seek some legal counsel on it, regarding determination. In our video, there's the Michigan Clinical Law Program, as well as legal services that you can contact us, as well as the Washtenaw County Bar Association, to see if you can get representation regarding this issue, okay?
Okay.
And then we'll figure out how we're going to proceed. I would adjourn the matter to November 7th, 2025 at 12 noon. All right, that's an in-person hearing, ma'am, so you'll have to be at the courthouse in person, all right?
Okay.
Okay, thank you, we'll see you then.
Thank you.
Riverside Apartments versus John Wilkerson and Joshua. Mr. Wilkerson is present. Mr. Fink?
Thank you, Your Honor. So it is a termination case, but it's a health hazard termination case. And technically, this is the first hearing. Mr. Wilkerson, of course, was scheduled for last week. This is an issue of the overwhelming pet odors in the building affecting other tenants in the building. Feces on the floor near the kitchen. I don't need to go over everything on
Got it.
on Zoom, Your Honor, but we would like the tenancy terminated. We also filed a 1-month lease violation notice to quit also on October 3rd. So next week, if we don't have a resolution, we'll file an amended complaint so that this is both a health hazard and a lease violation termination.
Got it. All right, Mr. Wilkerson, what's your position on this, sir?
Yes, sir. I'm moving. I have a new place secured as of November 7th. I just request a couple weeks' time to be able to move and clear out the unit.
Well, here's what I'm going to do. I'm going to adjourn this out 1 week to November 7th, 2025 at 3 p.m. That's an in-person hearing. What I'm going to suggest to you is you contact Mr. Fink's office and try to arrange the time frame for you to vacate the premises, okay?
Yes, sir.
All right.
Your Honor, 2 things.
Yes, sir.
Would the court please, for the ROA, note a default for Joshua Wilkerson, just in case we don't have him show up? And
yes, for Joshua defendant 2. Yes.
Could we give Mr. John Wilkerson advice regarding MCR 4.201J so that if he and I can enter into a COD for him to surrender possession, he won't have to come back?
Mr. Wilkerson, if there's there's a procedure by which there wouldn't be a judgment, but you would be consenting to move, as it seems to me that you are. There would be a conditional order, what's called a conditional order of dismissal. That may be able to be worked out. And if it gets worked out, you would not have to then come back after you sign it or give permission to have it signed. Okay, you understand that, sir? All
Yes, sir.
right. So
Thank
if
you,
that
Your
can all be worked out, I'm going to advise you of certain rights. And that is that within 3 days of my signing of that, you have the right to think about it. And if you believe that there's some legal confusion or some legal issue, some confusion on your part, some mistake on your part, or something that some right you didn't assert, you'd have those 3 business days to file a motion with the court to ask that that be set aside. You understand
Yes,
that, sir?
Yes, sir.
Okay. So you can enter into the agreement, long and short of it, you can enter into the agreement, but you have time to think about it after you've done so, okay?
Understood, sir.
All right. Okay, November 7th, 3 p.m. All right.
Yes, sir.
Thank you.
Thank you, Your Honor.
Thank
Thank
you. Your
you.
Honor.
That's it. That's it for that block. Wonderful. We're done till
noon.
nope, I'm not coming back in there. I got lunch. Am I gonna get lunch? You guys need to feed me. All right. Court is staying in recess. Court does call the case of Cross Street Apartments versus Hannah Schumacher.
Good afternoon, Your Honor. Norman Whitty, appearing on behalf of the plaintiff, Cross Street Apartments.
Your name?
Hannah Schumacher.
All right. And folks, where are we on this case?
Your Honor, if the court recalls, we had a first hearing on this over Zoom, and Ms. Schumacher raised an issue with trash collection at her apartment. And I've had a chance to talk to her and talk to my client, so I thought I'd give the court a brief update as to what the issue is.
All right.
And how we're hoping to proceed. The problem is that these are second floor apartments in a 2-story building, and the building's lot line is the building's perimeter. So there's no place to put external trash cans. Historically, there have been trash cans on the sidewalk. That's been the way it has been for years and years and years. Recently, the city of Ypsilanti's code compliance people have been ticketing and refusing to allow the trash cans there. There's no place else to put them.
So the city of Ypsi's been ticketing
the owner and tenants for having trash cans on the sidewalk. The problem is we can't put it inside the building. This is one of those buildings where you open up the door, there's a vestibule big enough for the door swing, and then there's a staircase going up to the apartments. So we can't put it inside. There's no place off street to put it because my client doesn't own any place off street. So I think Ms. Schumacher is very reasonably saying, I don't want to drive 45 minutes to my parents' house to get rid of my trash. And I don't have a problem with her escrowing the rent. I'm getting up to speed on this now. What I want to do now is go back, read the city's ordinance and talk to them about this problem and try to find a resolution. So I think the best thing to do would be to kick this back a couple weeks to give me an opportunity to sit and talk to the city and see if we can't find a solution that works for the city, for my client, for Ms. Schumacher, who absolutely should have a way to get rid of her trash on site.
What do you want to tell me? Thank you, counsel, for that.
I mean, I agree with pushing it back until the issue gets.
So that is very strange to me because I don't think in all the years I've been doing this that not having a place to put your trash has ever been an issue.
New one for me too.
I just have not heard of that. And when you were telling me at the first hearing, I'm thinking to myself, okay, what's this lady talking about? Thank you for getting that clarified because I wasn't sure when you were saying about the trash issue, and then we got the documents, and I'm still trying to. I'm like I don't understand. Like you just have no other place to put it.
Right.
So what have you been doing?
I've been driving at 45 miles one way to my parents' house to dispose of it properly.
That's not acceptable.
Bless your heart. Okay. Yeah, that's not. What other, are there other buildings around that?
And that's actually another part of the problem, is that there's another apartment building that my client doesn't own next door, and their tenants also tend to be putting things into any receptacles we have on the sidewalk. And so,
Did they have the same issue, you think, or?
I'm not sure about that. It's too early for me to know that.
Gotcha.
But, from my standpoint, Your Honor, I totally understand where Ms. Schumacher's coming from. My client has been diligently trying to resolve the problem, but they haven't involved me. And as you know, attorneys have some other tools that maybe
Right.
the manager doesn't have. So I'm hoping to sit down and see if I can't work a resolution of this.
And just one other question. So they've been ticketing the owner for the trash that's outside.
So for example, Jimmy John's is a tenant downstairs in the building, and they've historically had their trash cans outside for years and years. And now code compliance is saying you can't. So my client got a $200 ticket for Jimmy John's trash cans sitting outside.
Because Jimmy John's is a tenant of your client.
Correct.
Right.
My client represents the owner.
So, okay. I'm just going to ask this question out loud. I don't expect an answer because you probably, neither one of you probably know. How do you allow a restaurant to open without having looked at whether or not they have the ability to dispose of things? But you would have done that because that's the way they were doing it.
Well, so there's two answers. First of all, what Jimmy John's is doing now is they're keeping the trash cans inside and then putting it out around the collection times. But again, I mean, this building is an older building. It probably predates the code. My position is these are grandfathered uses because it's been done like this since the beginning of time. But saying that and having code compliance agree with me, there's a long path to walk between here and there.
Oh, have you dealt with the city?
No, I'm sure this is going to be fun.
Walk than you probably are.
We're going to find out.
Just gonna say that. How much time do you think would be?
I'd like to kick it a couple weeks and then come back by Zoom. I don't want Ms. Schumacher to have to come forward on these things because I don't think we have any factual disagreement between us. We're not going to need a trial. We're just going to need to find a solution.
Okay. And I'm just saying, if for whatever reason you don't get to where you need to be, if somehow or another you interplead the city, then I could foresee a settlement conference with you representing your client, Ms. Schumacher, in the city. Because that's right, she should not have to be doing that.
No, not at all.
All right. So I have 7th, 14th, 21st. Well, let's be right before Thanksgiving. So which would be better for you, man? Why don't we?
I'm sorry, what was the date?
The 7th, the 14th, and the 21st.
Of November.
If you watch more football, you'd be able to follow right along with me. But anyway, go ahead.
The 14th.
14th would be.
Or is there a later date?
I have the 21st.
That's fine, Your Honor. I don't expect the city to be moving at the speed of lightning either, so.
Your expectations will probably be, well, never mind. I'll adjourn this to November 21st, 2025 at 3 p.m. That's an in-person hearing. However, what I will do is I will allow the parties to appear via Zoom, given the circumstances.
Appreciate it very much, Your Honor.
All right. Anything else, Ms. Schumacher?
There will be no judgment.
Ms. Schumacher? I do a lot of these hearings, okay? Right now, don't you even worry about that. I think the ultimate issue is to try to figure out how to solve this problem for you. All right. I mean, certainly for the landlord, but really solve the problem for you. You shouldn't have to be doing what you're doing.
Just to give Ms. Schumacher a little bit of comfort on that issue. She's been very reasonable to work with. She's putting her money in escrow. I don't need an order for escrow. She's going to give me the information on that. And just so you understand, the most likely outcome, if we work this out, would be something called a conditional dismissal. And that would provide that you would then pay the rent because you're satisfied with the situation and the case is dismissed. So I don't see, based on what I know now, any point at which I'm going to ask the judge to enter a judgment against you. I mean, things could change, but I don't see.
And now knowing what I know, even if he asked.
And get it.
All right. Okay. Ms. Schumacher, thank you. You have a great weekend.
Thank you.
Patrick Becker versus Daniel Wolf. Cynthia Wolf and Aaron Wolf.
Good afternoon, Your Honor. Patrick Becker.
All right. Your name?
Daniel Wolf.
All right. And folks, where are we on this case?
We had an agreement to mutually terminate and dismiss the case if they had vacated the property by today. And
yes,
unfortunately, I stopped by the property and that's not happening. So I was going to show up and ask for a default judgment against the two defendants who didn't show, and then the ability to try to work something out with Daniel Wolf.
Sir?
We are moving out tomorrow morning. We have a mover scheduled at 9 o'clock. We tried getting them for today, couldn't do it.
A mover?
I'm sorry?
You tried to get a mover?
Yes.
And are they busy on Halloween? I don't know. Is that a thing? It might be. All right. Okay, so you're gonna move
tomorrow morning, 9 o'clock is when the movers will be there.
To move out. Okay. And what you were requesting was a default as to the two non-appearing parties.
Correct.
And then you did not want me to issue a judgment as against hearing, because you said you were going to try to work to the app.
Yeah. So,
well, tell me what you guys are trying to do, because
So what happened was rent started becoming late for a few months, and we had a group meeting in early September where I had agreed to again mutually terminate and not charge them any money if they just moved out by the end of the month. They explained to me they were having logistical issues and finding a place to live, and I understood that. The property does have a detached garage. It's about 2,000 square feet, so it's large. And I told them, hey, put all your stuff in that garage. You can find a place to go. From what I understand, they're downsizing. Unfortunately, throughout the month of September, they really made no effort to move and didn't go anywhere. They also did not pay rent. I had to file with the court. In October, we went through the same thing. I told them the same thing, that they could have the exact same options if they paid rent. They did actually pay some back rent, which is great. Currently, there's an outstanding balance of $4,921.40. Unfortunately, I don't have a lot of faith that they do have movers scheduled. If Mr. Wolf could show me that they have something, or more importantly, they have a lease signed and they're moving somewhere, I think I'd be more comfortable.
He's holding something.
And I'd be happy to show you the mover schedule on my phone. Fantastic.
Oh, hold on.
I did not.
Just hold on. You're good.
So
you have a new lease.
Yes.
That starts what?
Tomorrow.
Got it.
So I'm very, very, very good with that. So I guess what I would ask for is a judgment for the outstanding $4,921.40. I'm not going to worry about next month's rent. They can have tomorrow for free. And I'd be super happy. And I would argue that, Your Honor.
Pardon?
Mr. Becker has a deposit of $5,700 from us. Of that $5,700, there is rent owing in the amount of $3,900. But he can take from that security deposit. There's a delta of $1,800.
All right, I got you. Can I ask you a question now?
Sure.
You use the word delta. I understand why you. Well, I don't understand. What did you do for a living?
Engineer.
Yeah, okay. That's why. All right. I mean, I understood what you meant, and I'm just like, all right.
Sorry.
Okay. So here, if he's got a lease and they're out tomorrow morning, you were going to give that free. Here's what you got a security deposit, right? That would cover this amount? Is that?
It would,
It
Your Honor.
would? Okay, why don't I do this? And what I'm gonna do is I'm gonna decline to issue the judgment. I'm gonna put this out 1 week.
Fair.
If they move, that's fine. And then if not, you can, if they move, then you can do the inspection, determine what's owed. If the security deposit's gonna cover it, then I don't have to issue a judgment against them. You take the security deposit, delta and all, I guess. I don't know. Okay, I'm using it wrong. I'm a lawyer, didn't become an engineer because lawyers are never that exact. But oddly, my son is gonna be an engineer. Which is just like, well, yeah, well, my brother was, so I get where he gets it from, but it's like they're too like on point. All right, so that's I think the way I'd like to handle it. Do it that way, give him a chance to move out. I believe him that they can't get somebody today.
Sure.
For whatever the reason. So I'll adjourn it to November 7th, 2025 at 1 p.m. Now, I'll tell both of you this, and maybe communicate with each other. If everything's all set, you've done the inspection, you got enough to cover the back rent, and you guys would be satisfied in just taking that being done, they've moved out, everything's all set. I don't need you folks to appear here because then I can just dismiss the case. You wouldn't get a money judgment anyway, you'd be satisfied, everything be set. Fair enough?
Yeah, my biggest concern, Your Honor, is having a son, having a judgment placed against him. He's moved out of the house several months ago. And
okay, no,
quite frankly, isn't a party to this whole situation that we're in now.
Your son, Aaron?
Yeah.
Okay, and so I'm not going to issue any judgment. If everything's taken care of, everybody's out, the security deposit gets covered. If there's a shortfall in any way, you guys work it out. If there's not, then get that portion returned. Then everybody
We're good.
Okay.
Works for me.
All righty. Thank you, guys.
Thank you, Your Honor.
Thank you, Your Honor.
Take care. David Sawolski versus Lisa Laro. Lisa Laro. And what about Maria?
She's there.
Okay. Your name, sir?
David Allen Sawolski, sir.
Okay. And there was supposed to be a written answer filed. How much is a non-payment of rent case? How much is you did file it?
I wanted, I wanted a 1.5 month, $2,400 security deposit. And now she owes $3,200 in back rent because she can't.
Hold on a second.
What happened, sir, was I took over the property on September 26th. I bought it.
Okay, yes, I recall.
And so for her to stay there, I would want $1,600 per month. But that started on September 26th.
What was it before?
That was between her and the previous landlord.
So at what point did you give her notice that was now her monthly rent?
Same date.
In writing?
No, sir. I knocked on the door and she answered it, and I told her that I want rent if she was willing to
On
pay.
what date did you do that?
September 26th.
And so then you were going to charge $1,600 for October?
Yes, sir. If she paid
then
it,
let me just ask you this. Why do you think you would not have to give her 30 days notice at minimum before you change any condition of her rental circumstance?
I'm not sure about that, sir.
Yeah, I can tell.
Yeah.
So
we had no agreement.
He came to my door and my daughter was there. Both of my daughters were there when he offered me the agreement and said he liked my dog. He said that he did not want to bother me for a down payment and that he would honor the $1,200 a month.
Did you tell her that?
24 hours to think about it, and I called him back and said,
Hold on a minute. Okay, but
No, sir.
so what are you claiming she owes?
Well, for her to stay there, I wanted,
No, 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 no.
okay,
You filed this as a non-payment of rent case, saying
Yes.
that she hasn't paid rent.
yes, sir.
And in that complaint,
Yep,
you basically indicated that, first of all, your complaint doesn't say anything about how much she owes at all. That's blank. Then you're saying that the rental rate is $1,600 per month. What I'm hearing is that is not true. And
I originally offered her, sir, 1,200 if she paid me that same day.
okay. Your complaint indicates there's nothing about a $1,200 offer. I don't know what this whole offer thing was, and I'm not necessarily, at least at this point, going to get into it. But there was no agreement between the parties. And assuming she's, say, a tenant at will, or that you would change a condition of her tenancy, that you gave her properly 30 days notice to up her rent. Yet you filed a complaint that says that the rental rate is 1,600. Frankly, sir, that's false.
Okay,
Then you don't say you say no rent is due, right?
which item is that, sir?
Pardon?
Which item would that be on the complaint?
Look on your complaint, paragraph 5, C and D.
Yeah,
There's nothing.
yes, sir, I overlooked that, I'm sorry.
Then, so if, as you're indicating, you purchased the premises, if she were a tenant there, what happened to her previous security deposit?
I don't know that I have no idea. I have no idea if she paid one.
I did pay one, that's why I feel.
Well, hold on, just hold on, ma'am, just
What
take a breath, please. All right, how much did you pay as a security deposit?
It was 2,400.
Thank you. So if you purchased the premises, you would have had, she was still in the unit. That means you purchased it subject to, I'll put it in legal terms, her leasehold estate. You then become her landlord, which means that then you are the one that is responsible for the holding of her security deposit. So where's her security deposit?
I have no idea. The previous landlord told me she hadn't paid for 13 months.
That was
And-
sorry.
And he told me he had no security deposit.
I don't care what the previous landlord said.
Yeah.
But if you took subject to a leasehold estate, you would be required to figure out, I've got a tenant in there, have they paid a security deposit? Because then you're the one that would retain it, or he's got to return it to her. But I don't know how you ask her for another security deposit, because here's what would end up happening. Presumably, you've taken that $2,400 security deposit. That security deposit that is she previously paid, and any security deposit tenant paid, is never the landlord's money. It belongs to the tenant. Which means that if, as you want in this complaint, for her to pay another $2,400, that means she would have a theoretically a $4,800 security deposit. even if I were to permit you to have the $1,600 rental rate, which I don't think can be imposed, you would only be able, 16 plus 8 is what, 24? The maximum amount of her security deposit could be 24, which means that you would be charging her twice the amount of a security deposit that legally you could require that she pay, which is going to subject you to damages.
Okay.
So that's where we are. Be honest with you, I think you bought this property without fully thinking through what you needed to do. You can't force this woman to do certain things and just automatically like appear at her door and claim that your rent has gone up by a third.
Yes, sir.
On my say so.
Yes, sir.
Where in the heck does the $4,000 come from that you're saying that she owed? Oh, that's the 1,600 that you're claiming, which is the improper rent plus the improper security deposit.
Yes, sir.
That's where they comes up in the notice to quit?
Yes, sir. I wanted the 1.5 month security deposit plus the $1,600
You
a
need to
month.
go to the previous owner and find out where her money is. Because you're supposed to be the one now that's taking over a leasehold estate. You're the one that's supposed to retain it. And you're supposed to give her a notice of where you're retaining it.
Is she required, sir, to provide proof that she gave a security deposit to the previous landlord?
Yeah, I have my.
Hold on. You are requiring her to do some things and shifting the burden to her. I will call upon her to provide proof when it's necessary to provide proof, but I don't see anything in the beginning of this that you did that's right at all. Have you asked the previous landlord if he has a security deposit?
I did not, sir.
See? And so now what you want me to do is ask her whether or not she paid it. Quite frankly, I'm going to say this to you. Not sure what she wants to do. But what's going to end up happening is both you and the previous landlord are end up getting sued. So my question becomes, what do you want to do with this case?
Well, indeed, if she paid a security deposit to the previous landlord, and it looks like the security deposit I asked for is no good.
Well, but where is her money? The security deposit, did you hear what I said?
Yes, sir.
The security deposit belongs to the tenant and is to be held by the landlord, but it's her money.
Yeah.
So somebody needs to find it.
Okay. So I would need to contact the previous owner and see what.
I don't know what you would need to do. All I'm telling you is somebody needs to find out where her money is.
Okay. I'll contact.
Moreover, the complaint, while you certainly could amend the complaint, the one thing you cannot amend is the notice that you sent to her. That notice has numbers in it that make no sense based upon what I've just told you. However, you did file a notice that on its face looks valid, so I can't necessarily dismiss this case on subject matter jurisdiction. However, if you wish to proceed with this, you need to understand that at the very end of the complaint, and pursuant to the court rules, that you're signing that complaint under penalty of perjury. That information has to be true. I don't think that any of this is true.
Okay.
So you can make your decision as to whether or not you want to proceed with this case or not.
I think it might be better to dismiss it and pursue possession.
Well, because she asserted her rights.
Well, because if she
I
put
mean,
it,
sir, get what you did.
Yeah.
You went to this woman, told her, based upon some representation that somebody else made about whether she's paid rent, not knowing the circumstances. Not sure that was any of your business, but that okay. You took the place, didn't get her security deposit, asked her for another security deposit, and then try to increase her rent by 1/3. So here's what I'm gonna do. Okay. I'm gonna adjourn this out 1 week. You think about it. You try to figure out. I'd suggest you go get an attorney. Because if she turns around and files a claim, you're gonna have a heck of a time. I'm just gonna be honest with you. But that's gonna be your call. I am not, because it's not in her interest. She's unrepresented by counsel. I'm not going to, and she's appeared. While you're moving to dismiss, I'm not granting your motion to dismiss at this time so that she can also pursue whatever remedies she may have if she chooses to do so. So I'm going to adjourn this out to November 7th, 2025 at 1 p.m. That will also be an in-person hearing. And I am not precluding the two of you having a conversation, provided you want to approach her as your equal. Thank you.
thank you, sir.
Have a good day, ma'am.
1 p.m. November 7th.
1 p.m. November 7th.
Thank you.
Pleasant Lake Park versus Christopher Denoway.
Good afternoon, Judge David Morris on behalf of Plaintiff Pleasant Lake Park LLC.
Your name, sir?
Christopher Genoviak.
Okay.
Sorry about that. I'm a little hurt today. Had to step out of the hall. I'm a recipient of a SSDI at 100% since March of 2020. I just got some things I want to read. I don't know how the protocol is around here, but I'm sure you'll tell me.
Well, it doesn't start with that.
Just start with this.
No, it doesn't.
I didn't hear you. I'm sorry.
It does not start that way.
Okay. All right, cool. Thanks for your time.
Judge, this is our second hearing on a non-payment of rent matter. Current rent to retain possession is $495 with fees of $75, costs of $110 for a total amount of $680. We have had some discussions, but no payments have been made, and parties were unsuccessful in finding settlement. I should note, Your Honor, that it appears an answer was filed with the court, but I did not receive a copy.
We'll get your copy.
Thank you.
All right, sir, what did you want to tell me?
Okay. So they're not doing maintenance to force the default. I've spoken with an attorney, like one of those free attorneys that you call them, a number they give you on the form. I called one of them. They're like, yeah, you have like a brilliant retaliatory defense. I guess he's trying to do default and to quit. I guess I got the notice.
Do what?
I guess I'll just read what I have. I'll read what I have.
Well, let's not.
I don't want to jump the gun here, but I did. This kind of makes more sense. So they're not doing maintenance to force the default. They did not board up holes, but they set traps and they put poison outside the unit, like when they should have just boarded up the holes. This creature, it's like a rodent. It's like nesting underneath my bedroom, like my bedroom floor. The skirting was never fully pulled back when he promised me that.
We both saw this creature and he set traps that were too small. Like, and then he put poison outside the unit. He never pulled the skirting back to put poison on its nest. There are multiple entries around this unit. Please, let me continue. I'm really sorry for wasting your time. We really shouldn't be here.
Ma'am,
So the
sir,
skirting.
sir, you're not wasting my time.
The,
I'm getting paid.
Yes.
Go
Sir.
ahead.
Yes, sir. Well, I'm unemployed. I lost my job like a few weeks ago.
Okay, go ahead
because
with
of
your,
pain and
go
stuff.
ahead.
I know, I'm
Go
sorry.
ahead with your reading, please.
So the traps are too small. And Mr. Weasel, that's the name. That's the person trying to evict me right now. It's Mr. Weasel. Mr. Weasel and I both saw this rodent or creature, not at the same time, but it entered out of the lake. My rental unit is up against a small wooden line about 15 to 20 yards, and then there's a massive lake. So we've both seen this creature. It is fat, it is large, it's like a gopher, it's like a beaver rodent creature. So there's 10 points. There's 10 points, almost done. So the traps were too small. He put, and we both saw it. We both know it's big. So I was trying to do walkarounds, Mr. Weasel usually just sends his maintenance dude just to do the maintenance. And this maintenance gentleman is a kind man. He also lives in the park. And this gentleman also works for Mr. Weasel at the landscaping company. And let me point, for Mr. Weasel to send out this maintenance dude, he has to pay him double time. So he's a maintenance, this man is an employee twice for Mr. Weasel. So we did schedule one walk around, but I was late returning from cleaning up a church festival. I spent 9 hours at a church festival on Monday morning. I was cleaning. We had.
So if they get rid of this animal, then
yes, sir.
we're
Yes, sir.
all good.
We're all good. And let me just I have a couple more points. I know this is really going into banana town.
Do you know anything about the animal?
I did set up a trail cam.
Okay.
Okay,
sir.
But I don't want to use that. I need to finish my points. So he never contacted me. He was on the property twice doing maintenance that wasn't completed, and he never contacted me when I was in the house.
Sir, I'm going to stop you.
I know. I'm sorry. I'm
going to stop you. That means stop talking.
Yes, Chair. Sorry.
Counsel, do you know anything about this animal?
We know of the idea of the animal.
Okay, I have no idea what that means.
We've heard of the issue, but my client has not set eyes on any animal. The animal at one time maybe was a mouse, and then a rat, and a cat, and then a beaver and a badger. And so my client knows nothing about any real animal. Traps were set, the skirt was tightened on the manufactured home. He has been out, or his management has been out on multiple occasions and has responded to all legitimate requests. The defendant.
Sir, you need to turn around and face the front and not wander.
I understand the defendant. I understand the defendant set up trail cams. We've received no footage. We've received no recording. We've received no audio file, no video. The defendant claimed over the phone that there's hours of critter noise every night. There are neighbors to the defendant.
Let me just stop you for a moment. Might it behoove your client to just
board up the holes that are super obvious? I'm sorry.
I don't know at what point I said I needed help with my sentence.
I know, I'm sorry.
Then you need to sit down and be quiet. Be quiet then if you can't sit.
We're cool. Yeah, stand still. I know. I just gotta keep moving. I gotta keep moving sometimes. Sorry. I know. I'm sorry. I'm really sorry.
Might it behoove your client to just hire a company to come out and look and make a determination based upon evidence that they see as to whether or not this creature exists or not? Because quite frankly, if there's a company that goes out and they tell me, yes, there's an animal, then they can tell you how to eradicate it. If they say there's not an animal, we're going to be at a point that there's not an animal. And apparently not one that grows from a mouse to a beaver in no time at all. I've never heard of one in Michigan, but we'll see. All right. So how long, do you think your client would be interested in doing that, counsel?
Yes, Judge, I think my client would be happy to get an extermination company to come and write a report.
Yes. How long do you think it would take him to do that? Because I can put this over to the 7th or 14th. What would you? And I'm gonna order escrow, so.
Thank you, Judge. I think the 14th would be
A better thing.
better.
What does that mean? What is order escrow?
So I'll explain that in a moment.
Sorry.
I'm going to adjourn this to November 14th, 2025 at
2 p.m.
at 2 p.m. That will be an in-person hearing. How much is monthly rent? This portion,
Monthly rent is $12.50, Your Honor.
but portion of it is paid.
Correct. There was.
What's his portion? Do you have Section 8 or something like that, sir?
Just SSDI.
So you pay your full rent?
Yeah, I got, I'm not employed now because of the noises underneath my bed. Every night for 3.5 months. Like I can't sleep. I can't sleep at
Okay,
all.
your monthly rent is how much?
$12.50, Judge.
$12.50. All right, I'm gonna order escrow in the amount of $1,250. That is to be paid within 7 days of the date that it's ordinarily due.
I have.
You have to, and what I mean by escrow, sir, is you need to bring escrow to the court as funds, pay them to the court until this is resolved. When you bring it to the court to pay, the $1,200 must be in cash. We do not take checks or other forms of money. Understood?
Not understood. I have additional comments that I'm not sure if he just wants to like evict me in the future again. But the bathroom floor is sinking by like 1.5 inches. Like there's like a hole in the bathroom floor sinking. There's like a hole. And I've already made this maintenance request. And actually, so there's an animal. I found this out about 2 nights ago because I had missing food. There's an animal entering my living room through the vent. This is a trailer from the 80s. So like this past week, I've had like, and I know exactly which vent it is. And I've complained about that. So like there's now an animal entering my vent that I found out 2 days ago, and it's been eating my leftover food. It's going into my living room. This is a super old trailer, like massive. There's holes all around. He's already boarded up 10 feet on the main stairs. He's boarded up 20 feet on the south side, and I'm asking for like 8 to more 10 feet.
What is your next point?
So my next point is this trailer. So here's my official request, Judge. I want a state inspector. I want something from the state.
Then if you want a state inspector, you can call them and have it inspected.
Yeah, okay, so super. And then I'll find out about this private inspector in the future. Is that what I should be expecting? Because I want a state inspector.
I'm not gonna tell you to expect anything. You
Okay,
say
right.
you want it inspected.
I want an
you call and
inspector. I want
Find
a
out
state
whether or
inspector.
not somebody's going to inspect it.
The
What's your
bath-
next point?
My next point is the bathroom floor sinking. I think this unit should be condemned. It should be pulled off the
We
property.
all have our thoughts and our process. I
Right.
don't know.
I'm going through that process right now. I'm just.
Okay,
with green
wonderful.
thumb, so, but this unit needs.
Is there
needs
another,
sterilized.
point?
That was Judge. I appreciate your
Is
time.
that it?
Yes, Judge.
Thank you.
Thank you,
Have
Judge.
check the bathroom floor, please, counsel.
Yes, sir.
Judge, thank you, Judge. Thank you, Judge. Thank you for your service.
Chris, we'll be in touch about, we'll give you some notice before we go.
Hey, come here. You walk out of here with respect, whether you like me or not, I don't care. You will not treat this courtroom that way. Am I understood?
Yes, Judge.
Now you may leave and you will leave in an orderly fashion. Go.
Yes, Judge. I'm.
Go. Was that the end of that block? Thank God. All right, court couldn't stand in recess. We'll be back unless somebody wants to go right now. Yep, court does call the case of Mylan Pines versus April Palmer and Deborah Palmer.
Dallas Frickman for the plaintiff.
Oh, no.
Yeah, yes,
Oh, no.
it's true.
I know. Oh, no.
Good afternoon, Your Honor.
Is it too late for me to pass?
It's never too late.
Go ahead. Sir.
Under MCR rule 8.120.
Okay, start out with your name and what you're intending on doing. How about that?
Sure. My name is Sam Fisk, and I'm a student attorney with the Civil Criminal Litigation Clinic at the University of Michigan Law School. We're seeking to practice under Michigan Court Rule 8.120 under the supervision of Sarah Sallin to represent both Deborah Palmer and April Palmer in this matter.
All right. Good afternoon, Ms. Sallin, and permission to practice is granted. All right.
Good afternoon, Judge.
All right, you two, what are we doing on this one?
It's a termination
Mr. Freeman,
case.
you gotta, these guys, and
I know, it's a termination case, Your Honor. The lease is long expired. We're asking for a judgment of possession only.
all right. And what do you have to say, counsel?
We're seeking a short adjournment in order to file our answer next week.
That was last week.
Yeah, I thought, how long have you been representing the defendant?
We received the case in late last week, but we actually haven't received the filing documents from the plaintiff's counsel. We reached out twice last week and didn't receive anything. So we got the complaint and the summons from the courthouse itself. We still don't have an official notice to quit. So the grounds of the termination are unclear to us.
Understanding is there's no lease or the lease expired?
Long expired.
So you're saying you didn't get the notice?
No, we never received any of the filings from the plaintiff's counsel, though they reached out twice in the past week. So we've essentially done 90% of the legal work on the answer, but the actual substance of the legal claim, we didn't know really until we spoke to the client. Even then, it's not obviously clear.
That's gotta be a University of Michigan thing. I don't know how you do 90% of the legal work on something you don't know about.
Yeah.
I do. We didn't do things that way in Maryland, but that's okay.
Your Honor,
That's okay. They're teaching a new kind of law.
This is just a straightforward term.
I know.
There's nothing complicated about it. And
Well, except the counsel's claiming he doesn't have the documents, which I'm a bit confused about because I received October 24th, a week ago. And then you say ultimately you got them from the courthouse, but you didn't get the notice?
No, we didn't get any of the attachments. So we got the one-page complaint and the summons, but the notice to quit was not attached.
I'm gonna trust that he didn't get it, and I'll let take a look at it. I'll give him 1 week to take a look. I'll adjourn it to November 2025.
All right, thank you, Your Honor.
Time,
Thank you, Your Honor.
2 p.m. All right, thank you.
Thank you very much. Appreciate it.
Thank you, Judge.
That is it. That's an in-person hearing. And Melanie, you didn't say anything. What's up?
I was letting him take the reins for.
Oh, okay. All right, you probably didn't think a judge would just say, hey, what's up? All right, have a good weekend, you guys.
Thank you. Have a good one.
Barnes and Barnes versus Rosa Bannock.
Your Honor, Alex Friedman on behalf of.
Your name?
Rosanna.
All right. And where are we on this case?
In talking with Ms. Bannock, it sounds like she's filed a 539. Is that accurate?
You mean the
Hawk form?
The rental assistance? Yeah. She did.
Okay.
And so I think she's entitled to another adjournment in any event. You don't have an answer from them yet?
Not yet. I was waiting for an offer letter from my boss and then.
Pardon?
I said I was waiting for an offer letter from my boss and never gave it to me. So I ended up sending my first pay stub and my time card because he.
Oh, you needed to supply some type of, and so you didn't get the information from your employer that you thought you were going to get. So you sent what you could.
Yeah.
Okay, I got you.
Yeah.
All right.
I didn't want to sign the COD just yet because I didn't want to be ineligible for help. So I don't know I don't know how it works, to be honest.
Okay, you said a lot of things there.
Sorry.
We
That
offered her a
means you-
COD, but it hasn't been fulfilled
It
yet.
has, yeah, I haven't signed it.
You haven't signed it because you're trying to figure.
Yeah, I asked.
Okay,
So,
all right, that's,
plus the payment was supposed to be Wednesday, which I was kind of unaware, and they sent it to me yesterday. I got sent the COD yesterday, and the payment was supposed to be the day before yesterday. Yeah,
so the dates of payments need to, well, let me ask you this. The payment that would have been due under the COD, do you have that or?
I don't get paid until next week, next Monday, to be honest. And I thought I was gonna be able to pull the money out because the app that the thing that they use offers that you can pull money out. And I thought I'd be able to pull more than I thought, but I'm not.
I gotcha.
Yeah.
So let me just try to put it this way in a nutshell. The COD is not really objectionable to you. You're just trying to figure out everything.
Yeah.
And the monies you thought would be available aren't available, but you'll have something come Monday.
Yeah. My paycheck.
I gotcha.
And then she's also said that the funds for Hawk are not available until November to pay November's rent on time, and they'll pay the arrears.
The people at Hawk told you that?
That's what I was told last Monday.
Oh.
Yeah.
That means
Have funds for October.
Okay.
Yeah, I don't know.
No, it's okay. It's just that some of the funding's been a little bit weird, but if they told you that you're gonna get it.
Yeah, I guess that's what they, everybody?
Pardon?
I guess that's what they've been telling everybody.
Well, maybe, but that's not.
I don't know how it works.
Well, I used to know, and then all right, here's what I'm gonna do.
Sorry.
Let's do it this way.
There's a lot of things I've been trying to navigate lately. Like I just recently was a victim of domestic violence, and now I have to navigate that, being a single mom, and I don't have anyone out here. So all of this is just coming at me at once. So I'm sorry.
No, it's okay. And let me ask you this, are you, I'll adjourn it to November 7th, 2025 at what time?
2 p.m.
At 2 p.m. in person. And you brought up something, and just to explore, there isn't an issue of child support, is there?
No,
No? Okay.
I'm
All
not for child support because he can't hold a job. Which you will see me on Monday, by the way. So.
Okay.
You'll understand more
I
on
guess I'll
Monday.
say I look forward to it.
Yes.
But if you wanted, so that you know, if you wanted to pursue that, whether or not he's holding a job or not, does not necessarily stop somebody's obligation to pay for their child. So I will tell you that. We have a program here through our friend of the court set up through this landlord-tenant case where we provide assistance and a connect for you to talk to the people at the front of the court. We can give them your information so you can begin that process. If you would like not to do it, you can make your own choices, but we want to make sure that you can explore all options that you can.
Okay, I mean, you can still give me the information.
All right, well, what it is, we'll get your email, we'll send that off to the front of the court and they'll contact you.
Okay.
All right, fair enough?
Yeah.
All right,
Thank you,
sounds
Your Honor.
good. November 7th, 2 p.m. All right, thank you. Court does call the case of Burns and Burns versus Annette Brown.
I'm gonna move to dismiss that, Your Honor.
All right, very good.
She made that payment, that big payment.
She made it?
Yeah.
All right, case is dismissed. Wonderful. Take care. Court calls case of Amanda Raines.
Ellis Freeman for the plaintiff.
Oh, I was gonna say as he was walking up, I said, he is not Amanda Raines. All right. Your name, ma'am? All right. Mission case, where are we?
I have been unable to make any headway with Ms. Raines. Just a termination of tenancy, straightforward. She doesn't have a lease, not paying rent.
All right, ma'am, what's your position on this?
Good afternoon, Judge Simpson. So what happened was, thank you so much for allowing me to come back today because I was here last Friday. And because I got served a few days before last Friday, and I wanted to take the time to find legal counsel. And I reached out to U of M student legal counsel and left
The
messages.
clinical program? Yeah.
Anything back, and then I called Ypsilanti legal counsel like 10 times and I couldn't get through there. Like 10, it said unavailable to take calls due to high call volume or something over and over again.
Are you talking about legal services
Yeah.
over at Nipsey? Okay.
So I couldn't get any legal advice. So I just like trying to read things online. So this is kind of the breakdown. Stefan and I were together for, or I lived in that home for over 5 years. I always paid my rent. I paid half the bills. I paid for so much of the home. And we were going through a breakup, which basically turned us into a roommate situation. And I always paid my rent. And then he asked me for the rent, and I said, use it out of my rent credit because every year he kept my rent credits. And I asked him for it, and he would never.
Your rent credit, I don't.
Like taxes and stuff, because I paid half the rent. I never got a rent credit from him. And I said, okay, can you use the rent credits for my taxes towards this rent payment? And he said, done. So I took that as a yes. Well, I was looking for a place to live and I couldn't find anything. And I went from working a temporary job to not having a job to trying to find another job. And I said, I have $800 for you for the last 2 months rent. And I have it on text message. And he said, no, I don't want it. He goes, I want to stick to a time frame because he served me paperwork. And he's not the landlord. He is the landlord's son. And he does not have a current lease. His lease expired in 2011. And his mother said she would never give me a lease because we were in a relationship. So I am not sure what to do. I just received a new position with a new company and I just need time to move. And now it's on my record that I have an eviction. So I'm looking and it's going to be kind of hard with this eviction on there because I think that landlords can see that. And
well, I don't. Okay, go ahead.
I'm sorry. And it's just that I offered the money and he sent me a notice saying for non-payment of rent and I offered the rent and he declined it. And I have that, but I want
no, I got you.
My cell phone in, so it's all on myself.
Um. Okay, couple of things. I'm not sure as I look at this. There's going to be, I doubt you did, Mr. Friedman. But oh boy. Have you looked closely at the notice to vacate?
I can.
Couple of things. One, because we called it a 30-day, But theoretically, it's a 1 month notice. I mean, certainly there's a day issue, but the basis for the notification to vacate is for non-payment of rent for July. I don't know, did you get you have your copy, Mr. Fisher?
Yes, I have my copy, Judge.
You seen it? You got it?
Yeah.
So I'm not sure if this, I mean, read one way, this is a non-payment notice, but it would be defective in that regard. And read another way, if it's a termination notice, you can't have the basis for the termination to be non-payment of rent. If the basis for termination is that she just doesn't have a lease. So I think there's a problem with the notice. I'd have to look at that a little bit more closely, but I'm not sure that this notice is proper in its form to invoke the jurisdiction of the court. It would be my concern because of the language on it, but also because of the language this notice does not contain, which is required.
Well, obviously,
be on the scale for.
Yeah, obviously, we didn't draft it.
Yeah, well, I was making that clear at the beginning that you did not. The other concern that I have, and she raises a point, and it's been raised before, but I never had to particularly rule on it. In these cohabitation situations where rent is being paid in part, there have been claims about the rent credit. And I really do not feel like looking into everybody's taxes. I don't feel like any of that. But if in the filing of her taxes, she does not claim a rent credit or doesn't use what she's paid, yet in the filing of his taxes, he did, theoretically, that money, and again, I haven't ruled on it, and people would have, I mean, it's been raised, but I haven't had to rule on it. She would be entitled to that credit, is particularly if she's asking for that credit to go against her rental obligation.
Well, I think that the.
5 years. So I
Pardon?
don't have to receive my rent credit in 5 years that I asked for.
Well, Your Honor, hang on.
Well, the 5 years may be a bit much, but let me put it this way. I hear you, but I don't know that one goes back 5 years saying I didn't, because I'm not going to go into every little bit of the arrangement that the two of you had. I'm just not going to do that.
Mike, I think my client would like to just would like to address the court for
yes, sir.
A moment here.
Yes, sir. How you doing, sir? Fan of your YouTube. She received a couple credits for a couple years. I am happy to also not ask for restitution for previous months. I just want her to leave my home.
Restitution
or any back rent.
She hasn't paid in months, so we're not going to go down that road.
Yeah, I mean, all right. I'm just gonna say this. You two were together for 5 years, right? Somehow or another, you had some relationship. The relationship breaks off, and now one person wants the other party out. That's really what we're dealing with here. And now everybody's trying to bring these legal things in where that wasn't the issue before. Somehow or another, however you guys worked yourself into a relationship, you got to work yourself out of it and treat each other kindly and try to get out of it. She wants to go. I don't think she wants to stay. It's going to be an issue of time for her, is what I'm hearing.
And I offered her I asked her how much time she needed, and she said she wanted to address the court.
That's fine. And I get that she may want to address the court because you're representing him and she's
It's fine.
probably a whole lot, not a whole lot of trust now between the two of you. So
No, certainly not.
that's right. And I don't trust either one of you. So just saying that. All right. So I think I'd have to adjourn it out because I think number one, the notice issue needs to be looked at. Because I need to look at it because I'm not sure that the jurisdiction of the court's been invoked.
I understand. Obviously, I'm gonna send out another notice today.
Yes. So you understand that, ma'am? No? Okay. So that in order, without getting too technical, the district court is a statutory court. The only way I have jurisdiction over certain claims is that certain things have to happen for the court to have jurisdiction. For me to have jurisdiction over this landlord-tenant matter outside of venue that it resides in the area that I oversee is that the notice has to be correct, the notice to quit. That's what invokes the jurisdiction of the court. On the face of it, I will be honest, I don't think that this notice does, and I don't think I have jurisdiction. If I don't have jurisdiction, then the only thing that I can do with the case is dismiss it. I'm not prepared in looking at it to necessarily make that ruling when I see it right now. But I'm going to adjourn it out a week. When we come back, I may make the ruling that I don't have jurisdiction. If I make that ruling, it's dismissed. What Mr. Friedman is indicating is two things. First of all, he did not prepare that notice, and he wants that clear. And secondly, that he will be sending out a new notice to you, giving that 30-day period at this point. That would not waive any claims that you can make or anything along those lines. It's more a procedural issue than anything else. Did I confuse you more by saying what I said? Okay. All right, guys.
Thank you, Your Honor.
So I'll adjourn this to November 7th, 2025 at 2 p.m. Yes, ma'am.
Because I just started a new job, I had to take off today and it was my first week. Is it possible that I could do a Zoom call?
You can do a request and we will strongly consider it given the circumstance.
Okay.
All right.
All right, thank you.
Thank you. Court calls the case of Glen Oaks Cooperative versus Kaylee Andrews. No, she's here. She is.
That's a dismissal.
She's trying to make her way up here. Hello.
Good afternoon, how are you? I'm Kelly Andrews.
Did I say the wrong name?
No, you said the right name, wrong pronunciation.
Anyway.
Wow. 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 No, you said it right, but Judge, you mispronounced my name.
Okay.
Judge, you called me out my name. You see what she did now?
You called me late for lunch before, so I just want to make sure. Just make sure.
Well,
Kelly.
The good news is she has made substantial payments and we're moving to dismiss.
Kelly, do you have any objection to that?
No, sir.
All right, very good. This case is dismissed.
Thank
You have a blessed weekend.
Eric, can I approach for a second?
Yes, sir. Okay, well, we'll see. Okay. Yeah. You never bring me anything easy. All right. I said, you never bring me anything easy. All right. Oh. Yeah. Okay, we're back on the record. Court does call the case of our management versus Bobcat Bonnies and Matthew Bajard.
Ellis Friedman for the plaintiff, Your Honor.
They're not here. All right.
They never appeared, Your Honor. It was and we took a default on the record approximately a year ago.
And I've been trying to work it out. We set this hearing for them to object. At this point, although the terms are placed in, no judgment entered, I don't need additional proofs at this point, but given all of that, the court will enter the judgment.
Thank you, Your Honor.
The parties having had notice. So I will issue a judgment by default for possession. Redemption amount inclusive of costs in the amount of $27,069.70. However, I'll enter it in that amount with the writ issued in 10 days.
They have long since vacated.
Yes. Okay.
Thank you.
Thank you. Arbor Woods versus Shakiri Lee.
Good afternoon, Your Honor. Casey P87729 on behalf of the plaintiff.
Shakiri Lee. She is not checked in, and this is based upon her motion. This is a writ hearing. Yes, it is. And her not appearing, are you requesting that the writ issue?
Yes, Your Honor, we are requesting that the writ issue. We received notice of this hearing yesterday. We did not receive a copy of the motion that was filed by the defendant, if filed.
Let me just make sure it wasn't, was this my setting? It doesn't seem like it would be, but I don't see a motion from her.
Your Honor, we did file first the order of eviction with the court, and then we had filed an amended order of eviction because the payment had.
That's correct. That may be why I did it this way. Yeah, because she did not file a motion. The court set it based upon what had transpired in the case. But what I know why, because the number went to a different amount. Yes. So what I will do is we have the amended application in order for eviction. And I've signed it.
Thank you, Your Honor.
Thank you. Arbor Woods versus Ellen Patterson.
Casey Matson for the plaintiff.
Hello.
Hi. What's your name?
Marty.
Pardon?
Marty, M-A-R-T-I, code C-O-L-E. I'm the daughter.
You're the daughter. Okay. And you reside at the premises?
Yes.
Is Miss Patterson?
Yes, I do.
Okay.
My mom passed away in August.
Miss Patterson did. That's right. I now recall when we read it. All right, where are we on this case then?
Your Honor, there is still a balance due and owing. We are requesting entry of a judgment today. Miss Mari has failed to fill out a tenancy application and be approved for such. I do believe an occupancy application was filled out. However, in order to, continue the tenancy, she would need to fill out an application for tenancy within the community, which has not been done at this point.
So when was I supposed to fill that out? Because I thought that they were giving me till the end of November to vacate the premises. Nobody contacted me.
You're gonna vacate.
Yeah, I didn't want to stay past the end of November. I just wanted to the end of November to vacate the premises. That's all.
Your Honor, she did request until the end of November. However, my client was not agreeable to give until the end of November, so we would ask for a judgment at this point, with 10 days.
When did your mom pass away?
August 14th.
Of this year.
She did.
So you just been scrambling since.
Yeah, I don't know what's going on with our beneficiary not paying her rent for the time of me being there, but
Right, that's what you said the last time, that there was supposed to. They haven't paid it and you haven't been able, this person that's receiving the funds has
not done anything. So, and I'm not in contact with her, my brother, my sister. So, yeah. So, I mean, I don't know. In 10 days, that's not enough time.
You just don't.
Let
me ask you this. Okay. I'm going to grant them a judgment because I think it's appropriate in the case for possession. How much time are you really looking at that? If I said you got to get out, what's the soonest you could do it?
November 30th. Maybe a few days before, but I mean, I need that much time because I just started back working. So I do have a security deposit I got to pay when I move. So I have to say.
I got you. Right here.
I mean, we would object to that. This case was filed in September, so she's had at least 30 days already to.
Yeah, and I just started working this month.
It's her brother.
In October.
Okay, hold on a second. Ms. Manson, what's your name?
Yeah, we haven't spoken.
Who is he?
My brother.
Yeah, you can come on up, as long as y'all ain't gonna fight.
I don't even know what he's doing here, but yeah, whatever.
All right, so what's your name?
My name is John Covington Jr.
All right, so what?
So I'm Ellen's son. I'm here to kind of give a basic background to this situation. She has been at my mother's house for over a year now. With
who has?
Me.
Okay.
Not being able to keep complaining. It also already has had 2 evictions by my mother as far as paperwork when she's been at the home. I have talked to her too.
So why does this matter to me?
So I've talked to Arbor Woods of the situation of getting my mother's things out to put in my auntie's.
Oh no, that's what this is about. See, him and my sister have came over with a big U-Haul trying to put me and my kids out so they could remove all the furniture and take it. Those are my mom's possessions, and she did not leave them to him or to one person. And since I'm there, they gonna come and take everything so me and my kids can sit on the floor. Like, that's not right. And I would never do that to them either. When I leave, I'm taking everything with me. Period. And I'm moving. So why would he think that everything would be outside or that he could take it to my aunt's house? Me and my kids are using it as of now because we are staying there. And as like he said, we've been there for a year. We have.
Upon that situation, sir, it was to the point that the eviction had came out. That was the only reason we were over there to try to move the things. Upon that point, as you can, and there are lawyers right there, I'm pretty sure she can talk to who she's representing. She has changed the locks. Only reason I was at the house is I have a key to the house.
And I changed the lock because him, my sister, and my aunt tried to come over and put me out, and they tried to remove everything out of the house so we can have to sit on the floor.
I don't need to put any.
How are you removing the furniture, John, when me and my kids are sitting on it? How are you removing everything out the house and taking it to Pam's house when me and my kids are there using it? I would never do that to you. Shut up. What things? You don't have no thing. Listen, 2 officers came over. There was officers.
Be right with you in a moment.
I had to call the police on them because they came over trying to put me and my kids out and remove everything. So the officers told him, my aunt and my sister, that they cannot come over there and remove Nothing.
Okay, well, hold on a minute.
All I wanted was my stuff, which is.
You don't have nothing. Your clothes, I gave them to you when the officer was there and he said that's it. And he told you not to come back.
Hold on. So when you guys pulled up to the building.
No, I was here. I didn't.
Just stop.
Okay.
Don't interrupt me. You can
Sorry.
interrupt him all you want.
I'm sorry.
When you pulled up to the building, it said 14A District Court. Walked in here to District Court. I am not a probate court. I am not a family court.
Correct.
So all of this stuff that you guys are talking about, fine and dandy. I can't do anything about that.
I'm here to figure out the day as far as when she has to be on, so we can.
Well, frankly, sir, you don't have any interest in this and haven't appeared until today. So I don't.
I've been at work.
Well, I don't care where you were. I'm just saying I'm on my third hearing. And she's appeared at every hearing.
Mhm.
And you haven't been here. And now you come in here and talking about you want to know what date. I'll give the date because publicly I will that everything's going to happen. But everything else is up to you guys.
No, I understand.
Council, how much is owing?
Your Honor, rent to retain is $3,140.96. Cost of $186.00 for a total of $3,326.96. We would ask for that writ to issue after 10 days. This is a rented home. They don't have any interest in the home itself.
Got it. What I'm going to do is I'm going to find after finding no tribal issue as to the amount of rent that's due. I'm going to judgment for possession to the landlord. The normal writ date would be the 10th. I am going to extend it a bit, ma'am. I'm not going to give you the 30 days to do it. I'm going to extend it to the 14th. And at that point, the landlord can take it. So writ to issue November 14th or thereafter, 2025. Right? Thank you. I might want to check that hallway, Alan. I'm walking along and having a great day. And then all of a sudden, not. Let's try this case. Northville Crossing versus Barbara Bargo.
Casey Matson on behalf of plaintiff.
State your name.
Barbara Vargo.
I'm her husband, Michael Vargo.
See, when he says, I'm her husband, he says that proudly every time he appears. All right. Okay. Where are we on this case?
Your Honor, I have rent to retain of $2,016.44, court costs of $190 for a total of $2,206.44. Your Honor, I do believe this is the third hearing, so at this time we would request a judgment.
Right, but I get that you're requesting that. Where are you folks with everything?
Of course, the veterans have been slow responding. Drika Jacob at Washington's VA is working from home actually, and not as many hours. So she finally earlier this week got me information on how to apply online to a different fund through the VA, Emergency Assistant Trust Fund. And then I I couldn't figure out how to apply for it online. So anyways, I eventually figured it out, but I'm still waiting for a response. So I have the copies of me applying for that. Madden Litton from the Senior Housing Bureau was waiting on me to let her know where I was with the VA. And around Wednesday, when I was still having issues getting a hold of getting responses back from Madrika, I finally responded to her, but I haven't had a response back. She said there was an opportunity that she could help us. So
That was who, the
Senior Housing Bureau of
Housing Bureau for Seniors?
Mhm. Thank you.
Okay, and that's their fund where they could pay, she says you might have access to funding that could pay it all.
Right.
This agent Skip, or I can't remember what the funding's name is. Gotcha. Okay. Okay. So you've been working on it, trying to figure it out.
Right.
I'm shocked that the VA has not given you a response.
Well,
they did, but they didn't, and part of it is because they're not really open. And the beautiful whole process. We had this nice federal government that just won't work, and now everybody's trapped. And Ms. Manson, you and your client are going to be mad at me, but I'm going to tell you, we're going to come back for a fourth hearing. I'm not kicking the vet out unless I have to. I'm just not.
I do want to say that I own the house. We own the house.
I know. I got
So I don't
you.
know
I appreciate listen. I appreciate your entire circumstance. I'm just indicating that I'm not kicking a vet out because I know that there are programs there to take care of it, and that absent the ineptness sometimes of our federal government, this would be done. It would be paid for, and you guys could sleep at night, not worry about it. And I know since his difficulties, you've been struggling to try to make it all work. I'm not abandoning you at this point. It's just not happening.
Thank you.
That's just not the way I am. And plaintiff can be as mad as they want at me, and that's fine. I had people mad at me before. I got broad shoulders. I'm going to put it out 2 weeks so that the two things, so that hopefully the Veterans Administration can give an answer within that time. God only knows. But also the individual that you contacted at Housing Bureau for Seniors, if it's I think it's Skip, if it's that funding, tell them that you'd like to apply for that right away. I think what they're going to do is they're going to be waiting for the veteran to see what the Veterans Administration does before they do it, because some of that funding is limited. Ask them if you could get that so this can get paid.
Okay.
Now, how much is your monthly rent?
I think it's $896.
Okay. Are you in a position to pay anything toward your rent at this point?
Not at this point. He's only getting a certain amount, and we have, other bills of like $1,000 a month. And
that's what you guys are living off of right now.
Right now. And I had a job at Myers. It didn't work out. They let go a lot of part-time people at that location. So now I'm currently been looking for another job, and I have a job opportunity with the Salvation Army and where we live, our local one. But they're waiting on a background check.
Got it. Okay. So here's what I'm going to do. November 14th, 2025. What time? 3 p.m. And it's likely if we don't have a resolution, I'm going to give them a judgment, but we'll figure something out. What I'd like to see is that between now and that date that you at least put $200, about a quarter of what's owed to the landlord.
Okay,
Okay, it's not much, but don't have much to work with at this point.
okay,
Okay,
we'll figure something out.
all right. I know you will, and I know,
Every day, we're working on it.
I know.
Okay,
You guys take care.
I want to thank you, sir, so much.
You're welcome.
We'll bring you a sandwich next time.
No, no, you don't have to bring me anything. Thank you.
Thank you.
That's
guys.
it. I think that's it.
That is all for me today. Have a great rest of your day.
You do the same. Court does call the case of Evergreen Apartments versus Zelly Everett and Christopher Coyle.
You speak to the plaintiff.
Hello, what are your names?
Zelly Everts.
Christopher Coyle.
All right, where are we on this case?
Total is 32, 37, 72.
Okay, you indicated that you were going to pay $2,000 by the 27th. What happened?
Yes, I had a big bill I had to pay for. My car had to go into the shop and get a bunch of repairs. But I still plan on paying all of it.
Okay,
And
well,
I just started a new job, so.
well, here's what I'm going to do. I depend upon people when they tell me they're going to pay to do it. And not any of that got paid. So I'm going to grant a judgment for possession finding no tribal issue after a hearing. Total amount of the judgment will be 32, 37, 20, or 32, 77, 72. With a writ issue in 10 days. That's by the 10th. So you have till November 10th to get it paid, sir.
Okay, thank you.
Thank you. Court calls case Flowbar Apartments versus Mackenzie Parker.
You speak to the plaintiff. This total is 2187.
Parker, hello.
Good, how are you?
How are you intending on getting this paid?
Well, I did pay this.
She like 1977. This is the year I was born.
I did pay
Believe
the,
that? No. Okay.
sorry, I did pay the 600. I paid majority of it yesterday. I'm aware it was supposed to be due last week, but I ended up not getting the money like I thought I was going to. So I paid the whole 600. As far as the payment plan, they said it would be up to you guys, or I asked them how would the payment plan work, and they said it'd be week by week, but as far as the amount, it would be up to the court. That's what I
Okay,
was told.
so let me see. You paid the 600.
474.
No, I paid the rest of it this morning.
Okay, so how much did you pay this morning?
It was 126, and yesterday I paid 474.
Okay, so you paid 474. And then you
Yesterday.
paid 126 today.
Today, yes. So
Okay,
the
so
whole
you
600.
got to your 600. You
Yeah.
were just late on how it was coming in.
Mhm.
Gotcha. All right, so that still puts you in the realm of owing 2,000.
Yeah.
And you went to the office to try to work out a payment plan, you said, and
They messaged me about it, and I asked them how it would work, and all they told me was it would just be like an amount every week, and as far as the amount, it would be up to the courts. That's
okay, so hold on. They sent a message to you?
yeah, like a text message, like the office.
Oh, I have a note that says we can do a COD.
Okay. Okay.
Would you like to pass it and we can?
Yeah.
wrap it up when we're done with
Okay, so
everything?
what I'm gonna do, a COD, so that, because sometimes we talk in code, that's a conditional order dismissal.
Mhm.
So that usually lays out the terms of a payment plan to try to
Okay.
get you. So,
Okay.
so I'm gonna pass it so that you'll have an opportunity at some point to speak to Mr. Fink. and see if you
Okay.
can work out those terms.
Okay. So,
Okay?
So will I have to come back at all, or?
No, you'll have to wait a little bit here
Okay.
today, but hopefully we can get it done, all done today.
Okay, all right.
Okay? Why, you don't want to come back?
I mean, hopefully I can get it resolved. So,
Oh, so it wasn't a personal attack on me?
no, no, no.
Oh, okay, no, I was wondering.
Yeah.
I'm sensitive today. All right, court calls the case, Glencoe Hills versus Jerome Adams. You need to take your hands out of your pocket, thank you.
His total is 1755.99. Are you waiting for an adjustment from section 8?
Yeah, I was waiting on adjustment. They never sent the adjustment.
Your name?
Jerome Adams.
Okay.
Yeah, I was waiting on an adjustment from, I was waiting on an adjustment from them. They never sent the adjustment back. I think it was, I don't know what was going on with it.
You
Maybe
want a
because
judgment?
I said an adjustment.
Oh,
Oh, they was
adjustment.
I was waiting on an adjustment. And they never sent the adjustment back. Like, I don't know what was going on with them, with their paperwork.
How much is your monthly rent?
It was 5, but it was supposed to be going back down. It was supposed to be going to 0 when I lost my job, and they didn't do an adjustment on it.
Okay,
And then
so, go ahead.
I mean, that's why I was saying I was waiting on them to do an adjustment, and that's how the
amount.
process had
Right, I remember you telling me.
because of the it was just a lapse from.
So right now, what's your current rent?
I think 537 or something like that.
All right, can you get that into the landlord?
So the 530.
Yeah.
By when? Because I had went and applied for Rise and Hope too to cover the rest because I was gonna have like some court costs and stuff like that, and they was.
Gotcha.
I mean,
Okay, but what I'm trying to figure out, if I adjourn this out, to try to figure out that adjustment. I can't have you go further into the hole.
right.
Is what I'm trying to.
Yeah, but it was just really just like a paperwork thing with them with the adjustment. I had lost my job and it was supposed to go back.
No, I know. I understand what you're telling me, but right now your rent's set at 5, whatever.
Yeah.
And I'm wondering, can you get that paid? Are you working right now?
No, not right now. No, that's why I said. It was
So
supposed
you're
to go back.
not working at all right
Yeah, I was
Okay.
trying to get another job right now.
Are you expecting a retroactive adjustment?
Yeah, it was supposed to go back because they had sent me the first when I first had I lost my job. I sent them the paperwork, and then they was like I asked them for you have to send them to something. They had to send you the paperwork, and then I had to send them a packet back. And when I sent them back the packet they sent me, that's when they were supposed to do the readjustment.
When did you get that packet back?
It's been a couple weeks now, probably like 2-3 weeks now. Somewhere in between the 2 to 3 week range. I got the packet back to them.
14th, no writ without a hearing.
Okay, I'll do that. That way, at least the number stays where it is. Okay, so here's what I'm gonna do, sir. I'm gonna issue a judgment for this amount. I'm gonna extend the time to the 14th before they can do an order of eviction. But they can't evict you without coming back before me. Okay,
What you mean? Oh, we gotta have like another hearing. So what about with it just being like a mix up with the paperwork thing?
well, that's what I'm gonna do. Try to give them a time to do that. You're not gonna, you can still tell me that.
Yeah.
All right, and we can work that through. But what I'm gonna do is I'm just trying to lock this figure in
I see what you're saying.
and not
Let it pause.
have next month click into the
Tomorrow.
amount.
I got you.
So that if you have to get it paid, it's gonna be this lower figure.
Understood. I
You
see what
you
you're
get
saying.
me?
Yeah, I get you. I understand.
Okay.
You're Adams.
So after finding no tribal issue after hearing, I'm gonna grant a judgment for possession for the 1755.99. But a writ by the 14th, November 14th, 2025, and no writ without a hearing. All right?
All right, thank you.
All right, sir. Take care. Court does call the case, Glencoe Hills versus Miguel Lopez. And Rashay Collins and Samuel Lopez. All right, who do I have here?
Samuel Lopez.
Rishay Collins.
Okay, so no, I'm going to yell at Mr. Lopez. Now, why wouldn't you let the young lady give her name first? Why did you jump in there?
I'm about to say, I've been to court before. She hasn't. So, oh, I'm sorry.
Is that why you did that?
Yeah.
Oh, you did that because you're a veteran? Is that why? Like when I said one of your names, like she wouldn't know what to do? You about something. All right. How much is owing?
6, 15, 18.
16, 15, 18. All right, they made their $600 payment that they told me they were gonna pay. All right, you guys have a plan as to how you're gonna get the rest of this paid or?
Oh. They did make that 600 on the 24th.
Right, that they told me they were gonna pay 600 or had paid the 600 that day.
As far as getting the rest paid, I could or realistically, I could have it paid by the end of the month. I know I told you the 14th previous.
Well, the end of the month is today.
Or the end of next month rather, because I only get paid twice a month.
What day do you get paid?
The 10th and the 25th.
Huh?
The 10th and the 25th of every month.
So you get paid the 10th and the 25th. Okay. All right, folks. Here's what, and I'll explain why I'm gonna do it this way. But what I'm gonna do, I'm gonna find no tribal issue after a hearing. I'm gonna grant a judgment for possession of the 16, 15. How much is your monthly rent?
Around 1,200.
It's gonna be just under 3 tomorrow.
Right. So what I'm gonna do is I'm gonna issue the judgment for this amount. Okay. For the 16, 15, and 18 cents. I'm gonna indicate that you'll need to have that paid by the 14th.
Okay.
So I'll give additional time for you to get that done. Part of the reason I'm doing that is just that way you have to maintain your housing. You'll still owe November, but to maintain your housing, you gotta get this in. Follow me?
Yes.
Okay, and I think, oh, excuse me, I think that will benefit you. Okay?
Yep.
Okay.
Your Honor, I did not mark that as a default against McWell.
Yes, and the default as to defendant. You're, which Lopez?
Samuel.
You're Samuel, so it's a default as to defendant 1.
That anything of concern?
The other one, huh?
Oh, okay.
Same exact thing, yeah. Same exact terms. You have to the 14th to try to get it paid. Okay?
Yep.
Only difference between you being here and not being here is that he didn't get yelled at for.
Right.
Rashay,
Yes.
you have any questions?
No, sir.
Because he's just been talking.
No, sir.
You know, you understand everything?
Yes.
Don't let him do that to you. Okay? All right. You guys take care. Have a great weekend.
Thank you. You too.
Court calls the case of the people versus, or not people, Glencoe Hills versus Shayna Williams. You better hold that door for her.
I'm coming.
What? What? He got the second time around. All right.
James Fink for the plaintiff.
All right, they're on Zoom. Yes. Ms. Williams?
Hello.
Hello. Okay, where are we on this case?
Her total is 2132.
67.
Yes, sir.
All right.
Yeah.
Did you get your 700 in today?
I have it with me. I don't look like I'm at work, but I'm at work right now. I get off at 5 and I'm paying it as soon as I get off work.
Okay. And how are you gonna
I'll have the rest
Go ahead.
paid by the 14th. I think that's the date that y'all trying to give out for the next hearing. I'll have the rest of it paid by the 14th if
you can get the rest of it paid by then?
yes.
Okay, so here's what I'm gonna do. No tribal issue. I'm gonna issue a judgment for the full amount of the 2132.67 with the writ date of the 14th.
It's never mind.
Okay. You had a question?
No, well, I was gonna ask if I can get like until that Monday because I get off at 5, and a lot of places don't accept the payments.
Yeah, I'm gonna
after
set
5.
it. I'm gonna set it for the 14th. if you try to pay, they'll accept it.
Okay.
Okay, I get what you're worried about, but they don't want to come back before me and you got off at 5 and they didn't take your money.
Okay.
Okay, fair enough.
Thank you.
All right, you take care. Have a good weekend.
You too. Happy Halloween.
Okay, so thank you for saying that. People think I don't like Halloween. I do like Halloween.
You're welcome.
I don't understand it, but see, when you get to the point where you live out where you have no trick-or-treaters and your kids are old enough where they don't go trick-or-treating, you don't have grandkids, you don't have any of that, it's a holiday
just another day.
It's just a day, right? That people are dressed funny. That's all it is. All right?
Have a good
But thank
one.
you for the well wishes.
You're
All right,
welcome.
take
Bye.
care. Had to put that out. Everybody criticize. It's a beautiful holiday. right up there with Thanksgiving. Gulfside Lake 1 and 2 versus Hunter Rodriguez. Hunter Rodriguez. There is no response. I think I had you previously sworn today. You may proceed.
It's an action for non-payment of rent, Your Honor. Mr. Rodriguez owes $2,510.15 in rent. The costs are $172 for a total of $2682.15 possession only. The reason I hesitated is that he took the time to write a letter to my client, so I expected him to be here.
Judgment to the plaintiff. That is by default for possession, redemption amount, any amount requested with the writ issue in 10 days. Court does call the case of Gulfside Lake 1 and 2 versus Sarah Brown. Hello.
Hello.
What's your name?
Sarah Brown.
All right. Well, he's trying to find his number. Did you get that $1,000 paid?
I did last week.
Okay.
And I get
So-
paid every 2 weeks, so.
What do you have as the amount?
$2491.11.
That's it. Just paid that 1,000. And then, ma'am, how are you gonna get the rest paid?
I wanted to do a payment plan. I get paid every 2 weeks, so next week I put another $1,000 down on the 6th, because I get paid in the afternoon time. And then my other plan is my balance, I included my November rent, and then on the 20th, I could pay the rest of the balance.
In full?
In full.
Including November?
Yep.
Okay, so here's what I'm gonna do. I'm gonna issue a judgment for possession, finding no tribal issue after hearing for the total amount of the $2491.11. That defendant to pay $1,000 by I'll make it the 7th, that Friday.
Okay.
Okay. You pay $1,000 by the 7th. If paid, then defendant will pay the balance plus November rent.
Yep.
By the 21st, would that be?
Yeah, I'm gonna pay it. I get paid on the 20th. It'd be in the evening, but it should show up by the 21st early in the morning. Because I'm able to.
She's so honest. You can get it paid by the 21st?
Yes.
All right. Then if paid, then the balance plus the November rent to be paid by November 21st, 2025. And
Default as to Jalen Brown with the same terms.
Yes.
Yes.
Yes, cool.
And so that's a no tribal issue as to defendant 1. Default Okay, sign that. All right, thank you.
Thank you, Your Honor.
Have a great weekend.
Do I need to come back next week or no?
You want to come back and?
No, I don't.
You don't? Wow.
Well.
Wow. Yeah, oh, no, you could have paused before you said it.
I do love you, but I.
You do not need to come back, ma'am.
Okay.
You take care of yourself.
Thank you.
People just trying to hurt my feelings. Gulfside Lake 3 versus Emmett Redwine.
Good afternoon, Your Honor.
Oh, he's here. Okay, Mr. Redwine, how you doing?
I'm okay.
And Mr. Frank is gonna pay. Did you get your 700 in?
Yes.
So what do you have as a balancer?
74.
How much?
1370.74.
How you doing, Mr. Redwine?
How you doing, sir?
Okay, how are you?
I'm not gonna complain.
Okay, so Mr. Redwine, how are you gonna get the rest of this paid?
I can have it paid by the 14th.
You can? All right.
Yes.
And I'm gonna find no tribal issue after hearing and grant a judgment for possession in that amount of the 1370.74. That's to be paid on or before November 14th, 2025.
Okay.
All right?
Thank you.
I don't know what he's doing. Yeah. Thank you. All right, I've signed the judgment. I don't know, he just left. He just, huh? You get tired? Okay, no, you rest, man. I thought he was looking for somebody else to call up. Gulfside Lake 3 versus Erica Hall.
James Fink for the plaintiff. Total is 2379.29.
2379.
Okay.
29. All right. I did not see her over there. That's what she always does. I don't know what that's about. Hello.
Hello.
All right. How are we gonna get the rest of this day?
I just need to the 17th
17th?
of November.
Because right. I normally do the 14th before the weekend, but I'm gonna do 17th because you need that weekend. Yeah, I get you. So I'm gonna grant a judgment for possession, finding no tribal issue after hearing for the 2379, said 29, with a writ issue the 17th. Okay, you're all set. Thank you. Have a great weekend. New Park Ridge Apartments versus Yolanda Greer. And DeMarco Kilgore and Pravina Sanders.
We have this resolved. I just need to check one thing.
Come on out, man. You're fine. Hey, what's your name?
Yolanda Greer.
All right.
I have a typo with COD. Sorry.
I got the one Keisha.
I did wrong. Oh. She on?
Yes, she said she.
Your Honor, Ms. Sanders should be on Zoom. I asked her to log in so that we could.
Okay,
we could
sorry,
put the COD on the
I was trying to figure it out. I had my hand raised.
Ms. Sanders?
Good afternoon.
Can you hear
Can
me?
you hear me? Can you hear me?
Yes, we can hear you.
Okay, I can hear you
Your
now.
Honor, we've agreed to a conditional order of dismissal, allows the defendants to remain in the premises They have to pay their rent timely each month, but the rent will be considered timely if they pay half on the 1st and half on the 15th every month. They have a current arrearage of $1,968. They will pay that in 6 equal monthly payments of $328 on the 15th of each month, starting November 15th and going until it's paid in full. If they don't do that, then the plaintiff is entitled, and they'll comply with the terms of their lease. If they don't comply with the order, the plaintiff can submit a judgment for possession of writ of restitution upon the filing of an affidavit of noncompliance. The 14-day notice period, MCR 2.602 C2D, is waived. MCR 4.201 M4A is waived if the 56-day rule is an issue. We have 365 days to ask for an order of eviction. The lease remains in effect. There's no waiver of rights or claims under the Landlord and Tenants Relationship Act. There's no finding of fault. And as soon as you advise them of their rights under MCR 4.201J, then the order already has that they've been advised of their rights on the record. And I've sent a copy to Ms. Weidling, and one of us will sign Ms. Sanders' name if she gives permission.
Ms. Sanders, do you give permission to have your name signed to that agreement?
Okay, I agree.
All right, very good. You also agree, you're gonna sign
Yes.
your name, sir?
Marco Kilgore.
Okay, what, well, when I called your name, why didn't you come up? She told you to sit down, didn't
You
you?
saw what happened before.
Oh, okay. All right. Okay, I will grant that, and sign that conditional order dismissal when we have it. Do you have any questions regarding the terms, any of you?
No.
All right, and I would just indicate to all of you that after my signing of that, you have 3 business days to think about it. If you believe that there's some legal reason, some right you didn't assert, some confusion. Yes, ma'am.
I want to know, is there any way I can get some of the, court costs?
The agree.
Paid out, Judge.
Pardon?
Of course, the court cost is money that they paid out.
Yeah, right. They've already paid it.
Oh.
So that's a no. If you didn't
The
want me
late
to
fee.
sign it,
Late fees.
late fees. Well, I think they've agreed to a number, and I'm just gonna put it this way. Would you, if they waived the late fees, would you pay it all within 10 days?
You pay them 75. How much?
It's fine, just like.
Okay,
I mean,
and I'm just saying that
But it's Christmas, I got 3 small grandkids, babies. Yeah.
that's what I'm talking about. So they've given you a way to get this
Yeah.
done and still be able to do, okay?
I talked to Miss Dorsey yesterday, she just told me to throw it out there and see.
And see what Miss Dorsey, see, this is what I'm talking about. Anyway, all right. So you have 3 business days to think about this. If you believe that there's some legal reason, some right you didn't assert, or some confusion on your part, you can file a motion with the court within that time frame. You understand that?
Yes, sir. Yes, sir.
And Ms. Sanders, you understand that?
Yes, sir.
All right, fantastic. Then I'll mark this file as conditionally dismissed.
All right. Thank you. Have a good day.
Well, oh, so she said, do we get to come back to see? He goes, no. He did. Wow, man. I'm just hurt.
She said, need to, not get to.
No, I heard her say,
I-
get. I heard her say,
I
get to.
just watched the other version of him on TV.
All right.
When I see your name, I said, oh my God, is that the one on Quick Camp? I don't wanna go see him, I'm scared of him.
Why? I'm a nice guy. I have my moments, but I'm.
Okay, I have the right to sign.
Yes, yeah.
I should write her name on top of it. I know, it's a legal document.
Spelling counts.
Okay, that's the last one.
Of how many?
Wait, he's 30, he's 35, 26 and 23.
That's it.
Yep.
You're gone.
All right.
No trick or treat for me either.
That's what I'm talking about. All right, you take care.
All right, you too. Good
All
evening.
right, yes, good seeing you. Have a blessed
All right,
weekend.
thank you. Have a good day.
Thank you. Court does call the case, Peninsula Place versus Enrica Underwood.
Change the plaintiff.
He's right here. Hello, what's your name?
Enrica Underwood.
All right. And where are we with her case?
Her total is 430407. 4304.07.
All right. And how are you intending on getting this paid, ma'am?
So I'm planning to just make payments. When the situation is, I went to Disney World last year on an internship and I came back and things were really low and I paid my moving costs and was trying to make a payment plan, but I was not making enough at all to be able to like.
Okay, so hold on. You went to Disney World, an internship? Was that part of,
The Disney college program.
pardon?
The Disney college program.
Gotcha.
So, well,
So are you in school now?
yes, I go to EMU.
Okay, so you went and did that. You paid moving expenses to get yourself there to do everything.
Yes. And I was looking for jobs since last November. I didn't get hired. I started working. I got a job at the Standard in April. And yeah, so I just had to start then. And I just transferred from WCC. I have a half a little bill. I'm kind of in a situation right now, but I want to do.
Okay, so hold on, take a breath for me, please. All right. What are you studying to be when you grow up?
Musical theater.
What?
Musical theater.
Okay. What's wrong? All right, Doug, yes, lady. All right. Let's back up. How old are you?
29.
Okay, you're trying to get yourself through school. Trying to do everything so that you just have a better life, right?
Yeah.
And sometimes when you're doing those things, it all looks good and then it doesn't. Something happens, it doesn't quite work out, and then it's all looking different. And then you just think everything's all dark and you're not gonna make it through, right? All right. So what year are you in school?
I'm in my third.
Pardon?
My third year, junior.
So you made it through two. You're in your third year. And you're just trying to figure out how you can get through that and then the next one, right?
I will say that I started college. This is my second time in college. And the first time I dealt with some apartment issues and
You dealt with what? I'm sorry.
I dealt with apartment issues.
Okay.
And I know sounds irrelevant, but I recently paid off that debt this past year. So like literally earlier this year. So
That whole adulting thing is hard, isn't it?
Yeah.
Okay, listen. You're trying to do something with your life. And is the landlord open to some type of payment plan?
I don't have a note that says that, and
But she's trying to get herself through school.
she made a payment in early October. Got reversed for NSF. Then she did pay another 700 on the 17th.
Got it.
So
and I made a payment last night as well.
Okay, how much did you pay last night?
198.
Okay. paid what you had, right?
Yes.
Oh, I've got that. So her balance is 4304 after that payment.
After that payment. Okay, let's,
I just started working on campus and I'm going to start work study as well.
let me ask you this, young lady. Where are you originally from?
I'm a military kid.
You're a military kid.
My family is from Alabama and I grew up in Germany and I moved to Savannah, Georgia when I was 11.
Mom or dad in the military?
My dad,
Your dad? What branch?
Army.
And you're here trying to get through school.
Yeah, I had a VA scholarship at first and things didn't go well. But
But you didn't give up. All right, Mr. Fing. This is a veteran's kid. You know how I feel. She's also a young lady trying to get through school. You know how I feel about that. So everybody's gonna do what we can. We're gonna get her there. That's what's gonna happen from my book. So we can put it easy where we can do it the hard way.
Well,
I'm just gonna, I mean, I'm gonna be honest. And she went down to Disney World. I'm blaming it on that mouse. And that's why this is all messed up. It's the mouse.
You want to pass it and see what we can do today or adjourn it till next week?
Why don't I
want to
adjourn it
cut
till
her
next week
more
and-
slack on the redemption date while she figures it out?
Pardon?
Or more on the redemption date. The disadvantage, of course, is coming back.
She's got her November rent.
It'll include November rent.
Somehow or another, we gotta get her, we're gonna have to include that anyway. So we gotta get her straight so that she can get through this semester. I want her in a position where come her finals, that's what she's focused on. And then we can get ourselves into that next semester. That's it. I'm gonna adjourn it out a week.
1 week?
Okay, 1 week.
Okay.
And so what you need to do, young lady, is you got the number to their office. I need you to call them, work with them. Let's see what we can work out to get this done.
Okay.
Give me your email. Your father's still in the military.
He's retired.
He's retired
Sergeant First Class, Field Artillery.
Excellent.
in,
I have a son.
is he in Germany still or he stateside?
You're still stateside. Yeah. We live in Howell.
You know, okay. November 7th, 2025 at 3 p.m. Okay, you'll need to come back then. All right, how are your grades?
They're doing good.
What's that mean?
Oh,
My kids tell me that, and I have to be suspicious.
I have a research
What?
I have a research presentation to work on, but I'm doing good.
Okay, what's that mean? Good.
I'm getting all A's.
Are you?
Yeah.
Or you just he just told you to say that to me. He just told you to say that, didn't he?
No.
Fine. You're getting all A's?
Yes.
Bless your heart. Are you really?
I am, maybe with a B, maybe a B in there. I'm getting all A's, okay?
It just depends on how you look at it.
Yes.
Okay.
I'm getting all A's.
All right. Young lady, you're destined to be successful. So let's do our part and we'll try to help you through this little hump in the road, okay?
Okay, thank you.
You're welcome.
Your Honor, before we come back next week, or when we come back next week, I would like to remind you that Mrs. Fink has an active duty soldier right now.
Yes.
All right, thank
She
you.
does. All right. And so we'll get you through this, okay?
Okay.
All right. And when you talk to your dad, do me a favor. All right. He doesn't know me, but just tell him I want to thank you for his service. All right. And that I realize I get to do every day what I get to do because people did what he did. Okay? You're welcome.
Could we approach?
Yes. Okay, Peninsula Place versus Michael Pugh.
Same thing for the plaintiff. His balance is $2,044 even.
All right. That's where we were last time, Mr. Pugh.
So with this being the closest apartment to my college campus and me being currently laid off my job, I still was able to make a payment of 1,800. So it was more, but I made the payment of 1,800. And I was contacting the attorney and the landlord, and the attorney said they were trying to check with the landlord what was available to me. And I contacted the landlord and the attorney multiple times, and they still haven't got back to me.
Hold on a second. When you paid the 1,800 when?
But this was 2 weeks ago, so it was more than the 2,000. So I paid.
Oh, okay. The 1,800 got you down to the 2,000.
Yeah, and I was employed until now. So the thing with this job, it pays daily, but I don't start to the 19th. So I really just trying to see if there was a way I could make a payment plan until I start that job.
So let me ask you this. Between now and the next 2 weeks, how much can you pay?
The next 2 weeks, maybe 800.
And then you'll start your job, get paid. When would you have this whole balance paid off? Because you got November rent coming in.
So with this job, it pays daily. I say I get paid roughly like maybe $200 a day. So, and I work 4 or 5 days out the week. So I'm not sure how long that would take to make the balance, but it's like if I work 4 days a week, that's probably like $800 a week.
That you could put toward your rent?
Yes.
Yes?
Yes.
But you don't start that until the 19th.
Yeah.
I don't know how we're gonna make that work.
Do they still have short-term loans at EMU?
Not that I'm aware of.
Have you checked?
I tried. I think it was something with, I didn't get approved, I think, when I tried, but that was last year.
But you haven't tried this year.
No, because I was in this situation before, so I tried, but I didn't get approved.
So what, you didn't try this time, though?
No, because I really think the problem was probably the credit score. That's what it was.
How much is your monthly rent?
I say roughly 750.
With everything, it's about 1,000. The rent is 729. Utilities are another couple hundred.
What year are you in school?
My senior year.
What are you studying to be?
I'm trying to be a film producer.
So you graduate this upcoming year.
Yeah, I graduate in April.
You gotta find a way to get there. Where are you from?
I'm from East Point, Michigan.
You do all your 4 years up here?
Yeah, and then I've been at Penn since my sophomore year, so this is just like my last year. And I'm just trying to figure a way to pay all this off, so by the time I graduate, wherever I end up, I can have a new place instead of being in the Ypsi area, because I'm really planning on living somewhere where my job opportunity takes me.
Okay, so between now, you think you can come up with 800 between now and the 14th?
Yes.
You sure? Okay, so 2 things. Here's what I'm gonna do. I'm not gonna take a judgment today. I'm going to adjourn you out to the 14th. You need to get that, I'm gonna put in here that you need to get $800 to the landlord.
Okay,
Okay, by the 14th. Get it paid before that if you can.
okay,
All right, I'll work with you, young man, but you gotta do your part.
okay, thank you.
I'm going to adjourn it to November 14th.
Your Honor, this is over the plaintiff's objection.
This is over the
And
plaintiff's-
My concern is he's gonna be going backwards.
Pardon?
My concern is he's going to be going backwards.
If he doesn't get that paid, but what I'm trying to do is if he can get that 800 in, it may go up a little because of the other charges, but he'll be right in that same ballpark and then he'll be working. Right?
Yes,
So that's what I'm trying to get him to. So I am doing this over plaintiff's objection, November 14th, 2025 at 12 noon. You got to come back in and then we'll see if they can work something out. Now, the key to this is get that 800 paid as soon as you can, young man.
okay,
All right. Usually I won't let this click over into the next month, but I'm going to give you a shot.
okay.
All right. Partially because when I retire, I need people to keep paying Social Security. No, I'm kidding. All right. Okay. We'll do it that way.
Okay, thank you.
Blomar versus Parker.
Interesting for the plaintiff.
All right. Ms. Parker is present. And what do we have?
Your Honor, we have COD terms to put on the record, and then I'll get it in under the 7-day rule.
Okay, very good.
Her current balance, including costs, is $2,187. That's through today. Not in the order, but for the court's information, her rent is about $1,200 a month, including utilities.
Got it.
She's going to pay $800 on November 15th.
Okay.
She's going to pay $700 each month on the 1st and the 15th until the balance is paid.
Got it.
And until, not the balance of the 2187, but until her account balance is zero. So she's gonna fall behind up until December, and then she'll start working her way out.
Got it. Okay.
If she doesn't pay as agreed, we'll submit an affidavit of non-compliance judgment and an order of eviction. The 14-day objection period will be waived. We'll have up to 365 days to file a judgment or an order of eviction. No admission of wrongdoing, no waiver of rights under the Landlord and Tenants Relationships Act. I think that covers most of it. She'll comply with the other terms of her lease as well. All that good?
That makes sense to you? Yeah. Do you have any question regarding any of those terms?
So it's just, so as far as the 800 is just for this month, the 15th, and then everything after that is 700 on the 1st and the 15th.
Right.
Okay. All right.
So you don't have to pay anything for 2 more weeks, and then it'll go down. Okay, write your email address right there.
You said right here.
Yep.
Okay.
So I guess we need to advise her both of the 7-day rule and the 3-day rule.
Sorry. It's like,
Mr. Parker? Mr. Fink has mentioned a couple of things. First of all, the 7-day rule. What he's gonna do is he's gonna put all that together in paperwork along the terms that he's stated here on the record. Okay. He's gonna submit that to the court. Court will wait basically 7 days. If there's no objections to it, I will sign off on it.
okay, that agreement, right?
Right, that agreement. Then you also, because you're unrepresented by counsel, you have 3 business days to think about this. You believe that there's some legal reason, some objection, some misunderstanding, confusion, some right you didn't assert and you believe that to be the case, you'd have to file a motion with the court within those 3 business days, asking the court to set aside the conditional order.
Okay.
Doesn't mean I will, but you have that time period to think about it.
Okay.
Understood?
Yep.
You have any other questions?
No.
All right, I will mark this file conditional order dismissal, and it will be filed under 7-day rule. Thank you for your patience and waiting.
Thank
You
you.
take care.
Have a good day.
You too. Court calls the case of Riverside Apartments versus McKinney.
Like I still don't have the judgment, so we'll send it in. But Your Honor, this is an action for termination. I had it this morning. An action for termination of tenancy under MCL 600.57141E. It's pretty clear that the defendant has had a breakdown, for which we're very sorry, but it was disruptive to more than one unit, involved multiple calls to the police and a specific threat of harm to another person. We ask, it's been adjourned once, we ask for entry of a judgment upon submission.
All right. I'll grant judgment to the plaintiff. That's by default. I had here, we were going, I'm gonna have the writ date be the 17th, however, I think.
That's fine, thank you.
All right. On this one. Then I'll grant that judgment. All right.
I'll get that submitted, Your Honor.
Thank you. Thank you, sir. You have a great weekend.
Thank you. You also.
Arbor Manor versus Dayona Allen.
Thank you and good afternoon, Your Honor. Paul Huth, P31986, appearing on behalf of the plaintiff in this, I believe, third hearing.
Hi,
Hello, your name?
Diana Allen.
All right. And how much does plaintiff have owing?
Your Honor, the amount of rent to retain possession is $3,196. Court cost $172. Total amount $3,368. I believe your notes would reflect that the defendant was to make a $1,000 payment before the hearing today. I don't believe that payment was made. November's rent obviously will be due on the 1st, which is tomorrow.
So I did pay $700 before I got here. My check was only $750.
So you paid what you had, 700?
Yeah.
Okay.
And I also sent it to my caseworker from Washington Housing. And she told me, because she told me I had to get below 3,000.
Right.
So she said, starting early next week, they should start paying off the balance. And I also went up to the rent office, try to get a payment plan. But for some reason, she said the attorney told her that I said my grandfather was going to pay 2,000 and I didn't. I said I got approved from SOS last week. So I don't know.
Here's what I'm gonna do. I'm gonna find no tribal issue after hearing. I'm gonna grant a judgment for possession, for the 3368. Now, so that you can understand why I'm doing that. I'm not gonna adjourn it out a week because if I adjourn it out a week, we're gonna have to be clicking on November rent. Okay.
Right.
So we have a lower figure that you need to get paid off. If indeed you get below the 3,000, which you would be if the 700's been paid.
Right.
And they can pay it, then they'll pay the back balance. So none of this will have anything to do with November. If they want to come after you for November, they gotta start over or do whatever.
Okay.
Fair enough?
Fair enough.
All right, so we'll do that. I'll have her,
I'll confirm the receipt of the $700 before I submit the judgment.
all right, very good. And I'll make her writ date. I'm gonna give her some additional time because she's gonna get the assistance. I want to make sure it can get in. So I'm gonna go to the 14th, 2025.
Thank you, Judge. Happy Halloween. Have a good weekend.
Yes, sir. Thank you, and happy Halloween to you too. See?
And you said, what day I come back? I'm sorry.
No, you don't have to come back.
Okay.
Unless you want to just see me. You don't have to come back.
I'll come visit you.
Wow.
Thank you again.
Wow. Wow. I'm gonna stop saying anything. People are just hurting my feelings, you know? Oh, man. Pines of Clover Lane versus Rolando Eccleston.
Brad, take up the plaintiff.
Good afternoon. Your name, sir?
Rolando Eccleston.
All right, and where are we on this case?
Well, he just made a payment and he just showed me proof of the same. So right now I have rent at 908.24, cost of 175. So his total is 1,083.24.
I love it, 'cause he did everything he told me he was gonna do. He paid the 1,000, then paid the extra 1,000, so, all right, so when are we gonna get that paid?
The 14th.
The 14th,
Yes,
you
sir.
can have you can have that paid?
Yes, sir. The arrears plus the including of November.
So you're gonna have November and that paid?
Yes, sir.
All right, rather than give him a judgment, I know, I would normally try to do that. What I'm gonna do is I'm just gonna adjourn it out to the 14th. He's shown me that he's gonna pay, so.
If he gets it paid, we'll adjourn.
You'll
it,
get
and
it
we'll
paid, then
dismiss.
they'll dismiss it.
Yeah.
Fair enough?
Thank you very much.
All right, November 14th, 2025 at 1 PM. So if you get it paid, you don't have to come back and see me, which seems to be everybody's wish today. All right?
Thank you.
Thank you, sir. Thank you, Mr. Beal Properties versus Teresa Ijip. And Terry.
Good afternoon, Your Honor. Gabriel Lacey for Bill Properties.
All right. Your name?
Teresa Ijams.
All right. Where are we on this case?
I haven't started yet, but I have a job. I start on Wednesday. Once I've started the job, I should be able to get assistance from Hawk. So I will be able to start paying back.
Okay. How much is it?
Right now, Your Honor, the balance is $3,230. That's including the court cost of $214.
Got it. Okay, so ma'am, here's what I'm gonna do. I'm gonna find no tribal issue after a hearing. I'm gonna grant judgment for possession in the amount of the 3230. Reason I'm doing that today is I don't want November to click in. You're gonna, if Hawk is going to assist you, certainly if they get the funding, you're gonna need to be under 3,000, so you're only about 230 away from that. Okay. And then, like I said, this way it doesn't include November. I will grant that judgment that way with a writ date of the 14th. So I'll give you a few extra days to try to get that all situated. All right?
Okay.
Okay. Thank you.
All right. Happy Halloween.
Court calls case, Beal Properties versus Ebony Reese.
Gabriel Lacey for Bill Properties.
Your name?
Ebony Reese.
Right. And what is plaintiff's claim in this case?
Thank you, Your Honor. At this time, the past due rent is 2511 and 44. Court cost of 175. Total balance owed is $2,686.44. We have entered into a consent order for conditional dismissal. I'm just checking my email because the defendant wanted to see if we would waive court fees. And I do have a response, and that response is a no for my client on the court fees. This case.
So they're not waiving them?
That is correct.
Okay. So it's 2686. What was the change on that?
44 cents, Your Honor.
How was that? It was a condition. How was that to be paid?
So, Your Honor, the defendant will pay her monthly rent on time and an additional $200 a month on or before the 16th of every month until the arrears are paid in full. The defendant has agreed to waive the 56-day rule in consideration of the extended payment plan. Late fees will also be waived with timely payment. 4B is checked, and I did advise her of her rights under MCR 4.201, subsection J.
Ma'am, is all of that correct?
Yes.
Okay. Do you have any questions regarding that?
I do. As far as the court fees, I was questioning them because as far as when I was in contact with Bill's property, they said they do not want to evict me. We just wanted something in writing to handle the balance. And I received the balance from they weren't charging me rent for like 9 months. And so when they finally figured it out, because I had been telling them for at least like the first 6 months, like, I have to pay you guys rent, you're not charging me rent. They were just like completely bothered by me contacting, like, you have zero balance, you don't owe us, like, don't worry about it. So finally, after almost a year, they were like, okay, you owe like $8,000. And so I was like, well, can we do a payment plan? And so I told them I could not do the $500-600 a month, but that's all they would accept. And I didn't want to move because it's where my business is. And I have other people in my business. And so I accepted it, but I just feel like they almost are penalizing me for their mistake. And I would
except for the fact that
Mhm.
you know that you will owe some rent.
Mhm. No, I do know. And I will be honest, I was putting the money to the side for when they were finally let me pay it. And then life happened. I did use some of it. And that's why I never had an issue with paying it. Even once we came with the $600 a month, I just would pay late
Can I just say
sometimes.
this? I don't look at this agreement as in terms of penalizing you. When you first appeared here and even as you appear here today, quite frankly, the least of my worries are those court costs.
Yeah.
I'm just looking at is she gonna find a way to be able to get to pay this off? When Miss Lacy also started with the that there was a conditional order dismissal and that you when that I'll again be honest with you, I did not expect the terms to be that favorable to you. All right. I mean, I don't think they're trying to penalize it, but if I were to look at it and kind of balance it off with the whole concept of time and money, they just are trying to get the fees they paid out paid up. But
I understand that too, but also I started off with the over $8,000 balance since March, and this is what it's down to. So it also shows that I'm more than willing to pay it.
I don't think anybody is saying that you're not.
Yeah.
Okay. I'm just looking at it this way. Here are the choices. They're not going to waive those. The balance is undisputed. So either we take the conditional order dismissal or I grant them a judgment. And I don't think you want me to grant them a judgment. It would make you pay it by the 10th or the 14th of next month.
Okay.
Follow me? I mean,
I do.
If I didn't think it was fair in some way in looking at it, or that at least the agreement on its face was advantageous, I think most people that know me know I don't have a problem saying that. And I'd say you have to go back to the drawing board, but for me, I don't have a problem with what they're saying. I get what you're saying, but I also don't have a problem because the important thing is to make sure to work your way out of this and get back to just being able to do what you got to do every month, right? Okay. Any other questions regarding it?
I do. So have you ever handled a case like this where something like this happened? Like, it's never the company is held responsible for, like, of course, and I'm going to be honest with you. As soon as this happened, I contacted them for months. And it's like, what am I to do if you won't let me pay because you say I don't owe you?
Have I ever had a case like that? I don't know that I can think about one off the top of my head, but having been on the bench for 26 years, I'm sure I've had something exactly like it, just like it. And the real issue is this. Ultimately, when it's all said and done, is what's being asked for fair,
Mhm.
all right? The reality also is that if you hadn't had to use some of the money, which you,
Mhm.
I get it,
Mhm.
then the moment they filed, you could have said, well, if you waive the court fees, I'll just pay you this whole amount because I've been putting it aside. I
Mhm.
think they probably would have taken it at that point.
No, honestly, they weren't willing to even talk to me after like I tried to make arrangements. So, but I do understand that could have been asked for in the beginning. Mhm.
Okay, so what do you want me to do?
I mean, I'm okay with your judgment. It is fair. Like I told their lawyer, you know, I signed a lease. This is what I agreed to pay for the year, and I'm gonna pay it. So that's all I can do.
All right, any other questions you have regarding it?
No.
All right. Court will enter that conditional order dismissal along those terms, okay?